was told you expected fewer people, essentially.
I said fewer cases.
Oh, okay, all right.
Temporary relocation, if it comes 2 months from now, I'd like to temporarily relocate. I would like to, so we'll see, it's all about when they're gonna come. I'll send you a calendar. I've sent 2 emails to the property maintenance. It's just,
Are y'all ready?
Yes, sir.
Okay. All right. Good morning, everyone. The time is about 9:01. Welcome to the April Citrus County Code Compliance hearing. We follow an agenda at these hearings. You may have seen it outside the room. The first item is the call to order. We just had that. The next item on the agenda is the pledge to the flag, so I'd like to ask you to join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record should include the testimony and evidence upon which the appeal is to be based.
Okay, thank you. The next item on the agenda is approving the minutes from Wednesday, March 20th. That was our March Code Compliance hearing. I've reviewed them. Does anyone have any proposed modifications or objections to the minutes as currently formulated? Okay, hearing none, I'll go ahead and approve them.
Staff update, abated, and continued cases are listed out front.
Okay. So that brings us to the matters before us today. I'm going to read a short statement to you that I'd like to ask you to pay attention to. Good morning, my name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate close attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation and allow the county to present its case. You'll have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and or make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. At any time during the hearing, I may have questions of the parties, witnesses, or staff, and before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have an opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that I give you a time to comply before the fine begins, and you have to fix the violation by the date that I give, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on your property. The county has the right to foreclose on that lien or to seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, You'll be responsible for additional costs as well as the cost of the lien that's imposed. Although it doesn't happen often, I may continue your case as well if I find a need for further evidence or argument. You do have the right to appeal any order I make today as provided by law. Thank you.
First case on the day's agenda. Michael A. and James Lance, case number 2024-195. Code Officer Amy Becker, page 19 of your agenda.
Mr. Lance? Amy? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning, sir.
Good morning.
Good morning.
Amy Becker, Citrus County Co-Compliance Officer. This is case number 24-195, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 222 South Monroe Street, Beverly Hills, Florida. The property owner is Michael A. Lance and James Lance. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on February 6th, 2024. Photos taken on February 13th, 2024. Photos taken on March 20th, 2024 at my corrective action inspection. And photos taken on my final inspection, April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and pre-hearing order, and a signed certified mail return receipt signed for on February 23rd, 2024.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objections to them being evidence in this hearing. Take your time.
No.
Okay.
No.
And just for my own reference, is there anyone from the public who's going to want to be heard on this case? All right, I don't see any response. Okay, thank you. Without objection, what's been proposed as exhibits A and B is evidence. Please proceed.
On February 6, 2024, I conducted my initial inspection for accumulation of junk and debris and observed an appliance and some construction-related debris. As of my final inspection, there's been progress made. So the refrigerator's been removed, the trash has been removed, the construction debris on the side. They're deciding on how they want to proceed with the blocks. They've worked with me, so there's still a lawnmower and then the blocks that would need to be taken care of.
Is that it?
Yes.
The blocks?
The blocks and the lawnmower, and there's some other stuff on the left side of the home.
I mean, it seems pretty simple.
Yeah, yeah.
You've made a lot of progress.
Yes.
And unless you have anything else, I mean, really just what I would want to know is how much time you need before, to get it done.
Well, sir, just for example, I called to have a fence done. Two companies came out, and it was $9,000 just for that. I don't have that type of money, so what I'm going to do is put a fence up on my own. All this work is going to have to be done on my own, and then figure out what to do with the cinder blocks. So if I could please ask for at least an extended period of time.
Well, it's not a fence issue.
Yeah.
It's a,
The block, when I'm going to decide to deal with the cinder blocks and stuff. I
Okay.
called the building to find out what the proper placements would be. As
well,
far
what
as-
Ms. Becker's testified to is that, there's just 2 or 3 very minor issues remaining.
Yeah.
It doesn't seem to me like that would take a lot of time. In other words, it's not a fence issue, it's a blocks issue, it's just a little, I want to say it's not that much. So I'm curious how much time you need to just fix the junk issue.
Oh, the junk.
That's all I think that's all we're here on.
Well, the blocks, he's trying to decide what he wants to do with those blocks, but the blocks have been there for 6 weeks or 9 weeks.
Well, no, I
So
know.
at some point,
That's my point. I mean, I can grant you 30, 60 days, you know what I'm saying?
yeah.
But,
the lawnmower I can have out in a week.
You can have the lawnmower gone in 5 minutes.
I
mean,
tell you
I'll
what,
go
for-
do it for you.
Yeah, I will
I
do
mean-
that if that clears this up. Usually I'll throw it in the back of the car today and have that gone.
Yeah,
It
to
doesn't
me, the
work.
real issue is the concrete blocks. I mean, I just don't see it taking a lot of time.
Okay.
Is there any reason why it would take more than 30 days?
Well, I wanted to make a wall with it if I was allowed to.
I
make,
see.
you know,
Okay, I understand.
And if not, I wanted to maybe make a design in the front. Like just
Okay.
so many.
All right,
We
I
didn't
get it.
know. We had a few ideas.
I get it. All right.
That was the hiccup.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when they're ready for inspection.
Okay, I'll grant you 60 days. If it's not done in 60 days, $50 a day fine.
Yes,
All
sir.
right, good luck.
Thank you so much.
Thank you.
Thank you.
Next case on today's agenda, Paiute Real Estate Incorporated, case number 220-4346. Licensing Compliance Officer Keith Garner, page 25 of your agenda. Experts on the case, Building Director Samuel Costa, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good morning.
Sir, please state your name.
Nitin Patel.
Thank,
And sir, are you an officer of Pihu Real Estate
Yes.
Inc.? Okay. Thanks.
Randall Garner, Citrus County License Compliance Officer, case number 220-4346. Chapter 18, Article 1, Section 18-8A, obtain after-the-fact permit for all construction modifications of the Citrus County Code of Ordinance. Address 9895, North Citrus Avenue, Crystal River, 34428. Property owner, Paihu Real Estate, Inc. Good service via signed certified mail receipt, mail return receipt. And I would like to authenticate the following documents requested they be admitted into evidence. Exhibit A, photos taken during my initial inspection November 6, 2023. Photos taken at a follow-up inspection on January 23rd, 2024, and February 15th, 2024. Photos taken at my corrective action inspection March 15th, 2024, and photos taken at my final inspection April 16th, 2024. Exhibit B is a copy of the notice violation, copy of notice of hearing, copy of the certified mail return receipt indicating good service, and a copy of the pre-hearing order.
All right, sir, I'd like to ask you to take a look at these documents and let me know if you have any objections to them being evidence. Are you contesting that there's a violation?
Yeah.
You are? Okay.
Yeah, I know
Okay.
it's violation.
Is there anyone from the public who's going to want to be heard on this case?
This is Jody Lamar. Yes.
I don't see, okay, sure, thanks.
I already know it. Yeah.
Mr. President, maybe I don't, are you contesting that there is a violation?
I didn't pull a permit, so yes.
Okay.
We're working on it with my contractor.
So you're not contesting that there's a violation, you just want time?
We just
to-
want time, yes,
Okay,
yes, yes.
all right.
So, yeah,
Or redoing something?
yeah.
Oh, okay, so the remodel.
How much time do you think it'll take?
We started to apply the permits. He initially started it, but it was under owner permit, yes, and.
Oh, I
initially,
see, I
yes,
see, I see.
Yes, and yeah, so.
Well, what I'll do is I'll admit exhibits A and B as evidence. And I'll hear from the county and what's going on, and
Okay,
it doesn't sound like there's an argument here.
right.
Okay.
On November 6th, 2023, an inspection was conducted at 9895 North Citrus Avenue, Crystal River, and photos were taken regarding completed construction without required permit. During my inspection, I observed a walk-in cooler that was placed outside the commercial building without a permit. I was allowed to enter the building, and I observed no further violations at that time. The owner was told that a permit was required, and he said he would submit the application. During the follow-up inspection, I observed the new front doors and changed to the cooler. He was told permits were required for those doors as well. And at the corrective action inspection, additional work was completed with no permit being applied. During the final inspection, I observed extensive electrical, mechanical, and plumbing work had been done, and a stop work order was posted until all permits could be issued. His application with the county has been denied and no permit has been issued.
So what application was made?
There are permits that are in there that's been denied, and one of them actually is waiting revision, but the owner builder, with him being a business, can't be pulled as owner builder.
Okay. Can you help me? I may not be familiar with that. So as an owner builder, you can't do it if you're like
A corporation or
an actual
limited
corporation.
Yeah.
Interesting. Okay. They've presented some interesting facts, Mr. Patel. So it sounds like you kind of kept going multiple times. But when they say you need to get a permit, you got to get a permit, you know?
I did try to apply, then, you know.
Okay.
Yeah,
Okay.
I did do it, yes.
Okay.
Yes.
So what do they need to do to come into compliance?
He's got all of the stuff that he's done, air conditioners and everything that he's done. He's gotten his walk-in cooler up and running now. All that stuff. He needs a permit. He needs to stop doing the work he's doing and get a permit for everything he
Is
does.
it one permit or is it multiple?
It's multiple.
Because,
Right.
all right.
The air conditions were there. Air conditions was there.
The AC's back
The
there?
AC was there, but not on the walk-in cooler part. Are you talking about the air conditioning for the building itself? Or are you
Right.
talking about the air
Right.
conditioning were there,
Okay.
yes. Walk-in cooler, yes.
Yeah.
And the doors, yes.
And there's other walk-ins, cooler in the other.
That was,
adjacent
it
building.
was already in that building. We
Okay.
just moved it from one spot to another.
Okay.
I can take pictures because it was a convenience store.
Well,
So-
I mean, it sounds like you understand what has to be done. So the question is,
Yes.
how much time will it take? I would like to hear from someone. There's someone
Yes.
here who wants to be heard. I'd like to hear from them.
I'm Jody Lamel. I'm a certified building contractor.
Sir, it's sworn in.
Other hand.
Nice try.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Your name, please?
Jody Lomel.
Thank you.
Yeah. So I'd like to hear what you have to say.
So Mr. Patel's asked me to pull a permit for him. He's asked me for a month or two. I've been pretty busy, but he started a permit, and I did have plans drawn. We've got official plans from David King. We submitted them. I submitted them, but it's an owner-builder permit, and I did not notice that.
Right.
I thought I could do that, so I started the application.
Well, that's something
this
that can be
week.
fixed. I mean,
I'm sorry.
you know, you can fix that. You know.
Absolutely.
Yeah.
So
yeah,
we've
yeah.
got the form, and we're gonna try to take care of it right now to get the actual permit turned over to a contractor permit.
Are you helping out on all the things that need to
Yes.
be permitted here?
Yes,
Okay. Have you applied for permits here before?
yes.
How long do you think it'll take you to?
Hopefully, we'll take care of it here today. We
Well-
just need to submit a form to change the existing permit that I've uploaded the plans to. The plans have all been made, the documents or the engineered plans.
Is the violation abated at the time the permit is issued?
Correct. Oh,
Can we hear from the experts on this
I would
case?
love to hear from the experts, sure.
sorry, expert witness, Joanna Couture,
Yeah,
Land
go ahead, go
Development.
for it.
Sorry, Joanna Couture Land Development. There are some site issues here. They've added a cooler. We know there's a restaurant bar here. We know that, but there's some outside issues they didn't take care of in 2012 or are still not in place from their last permit in 2012 that they're going to have to meet. So the use has a little bit more than just plumbing, electric, and mechanical, which is what's building's concern is. There's some site issues. They're small. I think they can
So
fix it.
what you're saying, I think part of what let me know if part of what you're saying is, even if they get the permit for like the physical stuff they're building, there's a use issue.
There's a site issue. Not the use is fine. It's
Okay.
just some of the site, some of the outside stuff they have to do. There's
So
a little
they
bit
won't
more
be able
to
to
it.
get permits until they.
Not today. Yeah, they might get plumbing, electric, mechanical, but they're still going to need a site permit to do some of the outside stuff that they've done, such
And-
as the walk-in cooler.
Do they need to submit separate plans for that?
They need to
kind
submit a site plan. I haven't seen their owner builder because that wouldn't come to us, but yeah, they will have to have a site plan if they haven't already. We have one from the past that they can use.
of? How long a process does that normally take?
It's a couple weeks from
Okay.
submittal. It's not too bad. There's no new impervious. I don't think there's a stormwater issue. I think this is just it's small.
Okay, that's good to know. Thank you. Anyone else?
Did I observe I recall seeing some photos with the interior walls that were bare studs?
Yeah.
Is that space conditioned airspace?
Beer studs.
You said there was existing AC air conditioning there.
Yes.
So is that the space in question, that would be the condition? Well, I would question the likelihood that the air conditioning was permitted, because you cannot air condition spaces that don't have insulation.
So
So
what-
that would be part of the review process.
exactly. So whether that's the case or not,
Right.
that's relevant for me in granting an amount of time. Okay, so it means I'm not going to just say 30 days necessarily. But because of the lingering issues, I'm probably not going to do a minimum fine if it doesn't get done. What is the county's recommendation?
County's recommendation, the Citrus County License Compliance Division respectfully requests that the special master assess a fine of $200 per day, along with the administrative cost to begin after the date you deem sufficient to abate this violation. The amount was selected based on the action of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would ask that the special master also find that the respondent's responsibility to contact the License Compliance Division when the violation has been abated, so we could re-inspect.
Okay, I am going to find that there's a violation, but I'll grant 60 days to get it done, and if it's not brought into compliance, $200 a day. Okay? Thank you.
Yeah, thank you.
Next case on the day's agenda, Precise Property Management, 2020, case number 2024-131. Licensing Compliance Officer Timothy Williams. Page 28 of your agenda, expert on the case, Samuel Costa, Building Director.
What page of the agenda?
28.
28, sorry. Thanks.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning. Timothy Williams, Citrus County License Compliance Officer. This is case number CE 2024-00131, Chapter 18, Article 1, Section 18-A. Obtain after-the-fact permits for all construction or modification of the Citrus County Code of Ordinances. Address is 10022 East Bass Circle, Inverness. Property owner, Precise Property Management. Good service of posting at the property and the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted as evidence. Exhibit A, photos taken during my initial inspection on January 25th, 2024. Photos taken at my corrective action inspection on March 1st, 2024. And photos taken at my final inspection on April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of notice of hearing, a copy of the pre-hearing order, and a copy of my posting affidavit and a photo of the NOH posted at the property.
Is there anyone from the public who's going to want to be heard on this case? I see no response. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence? Go ahead.
On January 25th, 2024, an inspection was conducted at 10022 East Bass Circle, Inverness, and photos were taken regarding the expired permit for the replacement of a mobile home setup and installation. During my inspection and research, I observed the mobile home sitting on the home site and a permit that was issued on June 29, 2023, and that has expired on December 26th of 2023. A notice of violation was issued on January 29th for an after-the-fact permit. At my corrective action inspection on March 1st, 2024, and my final inspection on April 16th, 2024. The property remains today the same without an issued permit.
Have they constructed or modified the structure at a time when the permit was expired?
No, they just set it on the property. They had a permit, it was issued, and they just left it sit for,
I have no doubt that the permit's expired. But what it says here in the code section is that basically no changes shall occur without first having obtained a permit. They did get a permit.
yes,
Where's the violation?
it's, the permit has expired. And they-
I get it, but I'm trying to understand where the language, you've conceded that they're not working without a permit. You're just telling me that the permit expired. I don't see any violation in the code section for an expired permit or anything like that.
It expired and it didn't get passed.
Was they ever issued a CO or anything?
No.
No. Hopefully not.
Here's what the code section says, and let's look at your notice of violation. Your notice of violation says, Chapter 18, Article 1, Section 18-8A, construction or modification of a structure without required permits. That's not true. And then in the code section itself, it says, no person shall erect, construct, enlarge, alter, repair, move, improve, convert, change the use or occupancy, or demolish any building or structure subject to this code, et cetera, et cetera, et cetera, without first having obtained a permit therefor. Any person commencing construction for which a permit is required without having first obtained such, et cetera, et cetera. All this section requires is one thing, and that's that they don't do stuff without a permit. They did do stuff with a permit. So this case is dismissed. All right.
Next case on today's agenda. Tim Bennett II and Karen Genda, case number 2023-01201. Code Officer Julie Wilkinson, page 5 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
And I'm sorry, what page of the, I just missed it.
Page 5.
Thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you please state your names?
Karen Genda,
Tim Bennett.
Thank you.
Thank you and good morning.
good morning.
Julie Wilkinson, Citrus County Code Compliance Officer. This case number is 23-01201. Special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 6919 South Sorrel Avenue in Homosassa, Florida. The property owner is Tim Bennett II and Karen Ginda. I have good service via posting the notice of hearing on the property and at the Lecanto Government Building. I would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, photos taken during initial inspection on November 14th, 2023. Photos taken during a corrective action inspection on March 18th, 2024. And photos of my final inspection conducted on April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the photo of the notice of hearing posted on the property, and a copy of the posting affidavit.
Ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you object to them as evidence in this
Okay.
hearing. Just so I know, is there anyone here from the public who wants to be heard on this case? Sometimes I forget to ask. Thanks.
Okay, that's all done, so. This was yesterday? No. That was. No.
No objection.
Okay, thank you.
You can start.
Okay. What's been proposed as exhibits A and, just A and B? Is it A and B?
Yes, sir.
Okay, are admitted as evidence. Thanks.
On November 14th, I conducted an initial inspection and observed a boat, RV, and multiple vehicles, construction material, miscellaneous junk and debris on the property. On November 15th, 2023, a notice violation was issued for special requirements for accessory uses, which is a violation of the Land Development Code. A subsequent inspection was conducted on November 30th, 2024, and progress had been made. The property owner, Mr. Bennett, was actively loading a vehicle and removing it from the property, and he stated he is working and getting all the vehicles removed. So additional time was given to come into compliance. On March 18th, 2024, corrective action inspection was conducted, and there was still a boat, RV, and vehicles, miscellaneous junk and debris being stored on the property. As of my final inspection on April 16th, 2024, the property remains in violation. A permit was issued on April 3rd, and my expert on the case is Land Development Director Joanna Katu.
Okay.
Yeah, they did apply for a permit for a mobile home on March 25th. The permit was paid for and issued on April 3rd, so now they need an inspection. So once they call for an inspection and get the inspections, they can get the CO and have established their principal use then.
Oh, okay.
So they're close.
That's real close. I mean, all they have to do is call, get the inspection out. Assuming it passes inspection, then
Right.
everything they have on the property will be okay.
It's not junk, right? It was just debris.
Well,
Right.
I don't have a junk.
Yeah, that's what I'm saying. So
Yeah.
I don't think it was, so.
Okay,
yeah.
gotcha. All right. Does this all make sense?
Yeah.
Okay, sounds
When-
like you're very close.
When we got that property, we spent $10,000 at the dump, okay? The place was a disaster. The boat she's talking about was there.
Yeah.
It's big. I have it on my trailer right now, but it's too heavy to haul.
Yeah.
The junk or whatever she's saying is 2 metal buildings I have. She says I have to have them in an enclosure. Well, I was gonna put one up.
Well, to be clear, none of that is at issue, it
Right.
sounds like. The only thing
We have
that
a
needs to be
building
done is
permit.
you get that inspection, you pass inspection, you're good. Well, no, I mean, hold on. How much time do you need to go get an
The
inspection?
mobile will be
We
set,
ordered a new
Yeah.
home, so we gotta wait for them to bring it.
so at the
Oh,
end
I
of
see.
April, beginning
Yeah.
of May, it'll be set, then we'll be
I
able to
see.
see it.
Hopefully.
That's the holdup.
I see, okay. So you can't get the inspection until, all right.
They said it's 2 to 4 months to get,
2 to 4 months
Yeah.
from,
to get the
from,
house
from
there
when?
and put it up.
When do you expect to have it?
A month ago is when we.
Yeah, they said, like I said, somewhere at the end of April, beginning of May, so we're really close. That's,
Do you have to, have the permit before that's done?
Yeah, before it's placed, yes.
Yeah,
the
okay, so,
permit's
you-
active, yes, sir.
Yeah,
but, so what they're saying is, in order to get the permit, you have to do an inspection. It doesn't have anything to do with placing, you don't have to wait, am I wrong?
Yeah.
Okay.
The inspection is the final after it's set up.
Okay,
So they
do
have
have
the
to set
permit
it
in
up.
hand, they have to have however much time they need from their dealer to put it up, and then call for the inspection.
Right, okay, that's what I originally thought, okay, thank you. So how much time do you need for all this to take place?
Unfortunately, we are at the mercy of them setting
I
it,
agree.
so
Yeah,
if it's the second week of May, there's nothing we can do.
Whose phone is that, or is that?
Pass my work phone, sorry.
Okay.
Is that yours?
And you don't have it,
Possibly.
okay.
Sorry about that.
Fair enough. All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, we'll grant 60 days, 2 months from today, or from the order should be enough.
It should be fine, yes, sir.
And if not performed within 60 days, it'd be a $100 a day fine.
Okay.
So, all right.
What
good luck.
if,
Yeah.
we're not in, control of when they bring the house?
Well, that's not exactly true. I mean, this case has gone on for a while. The property was in violation. You were granted time. I'm giving you an additional 2 months to get it done. I do think that's enough time. All right,
Okay,
so
thank
good
you.
luck.
Thank you.
Next case on today's agenda, Christopher Contos, case number 2024-345. Code Officer Julie Wilkinson, page 8 of your agenda. Expert on the case, Joanna Coutu.
And just a note for everybody, when you come up, I should have said this in the opening statement, but if you're not contesting the violation, if you're not going to argue with the county that a violation exists, just let me know, because then we can go to try and talk about how much time you need. All right, thanks.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Oops, we have another one.
I do. It's almost like I'm getting married again.
I'm gonna have to swear you in too, sir.
Oh, she's saying she has to swear you in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And can you both please state your names?
Larry Cinta,
Can you spell that, please?
Scinta.
And you're Mr. Contos.
Yes, Junior.
Thank you.
Thank you. Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2300345. Of a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 5032 Westfield Street, Homosassa, Florida. The property owner is Christopher Contos. I have good service via posting the notice of hearing at the property and in the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 29th, 2024. Photos from a corrective action inspection on March 22nd, 2024. Photos from my final inspection on April 16th, 2024, and an aerial photo dated 6/6/2023 from the property appraiser's website. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the notice of hearing posted at the property, and a copy of the posting affidavit.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence at this hearing. And are you contesting that a violation has occurred?
No, sir.
Okay. How much time do you need to, and I want to hear from the county's expert, but how much time do you think you need to bring it into compliance?
Actually, if I knew ignorance is no excuse where I would be now, we wouldn't really even have to answer that question. But whatever it's going to take, I would like to say that prior to me even purchasing the land, which is adjacent to my, I'm good with that.
There's no objection, yeah?
No, sir. The property on South Chad Point, I have a .51 acre, and there's a property easement with power lines
Mhm.
behind me, and there's 5 acres, and I had called with Lucucci. We were going, this one owns that one. So I found out what exactly I could do.
Well, without objection, let me just say this.
Okay.
The proposed exhibits are evidence, but
Yes,
go
sir.
ahead.
So the Duke with Lucucci thing, I got that squared away on what I can and cannot do with the easement. Prior to that, before I bought the land, I had called the county a couple times, and I believe I spoke to Miss Donna on what I can and cannot do. Unfortunately, I was never told I could never, don't cut any type of trees or clear it. A lot of the trees that I did take care of, or that I had help with, were turkey oaks. There were no live oaks at all. The gentleman that helped me or assisted me, I didn't hire him. He was a friend of mine. He's in the tree business for several years, like many years in Citrus County. And I talked to him. Another thing, let me rewind.
Actually, no. I
I'm
thought
sorry.
it would be a simple question.
No.
So
I
what
mean,
I was
I never
asking is
got a
just whether,
certified
I'm
butter.
sorry, I'm still speaking.
Go ahead.
What I was going to say is I thought that, I just wanted to know if you were contesting it.
No, sir.
I don't know, but the county may also be requesting a fine. So now, because I've heard so much, I actually want to hear what the county has to say. I'm sorry.
That's all right.
I conducted my initial inspection on February 29th, 2024, and observed that the property had numerous trees removed and a limestone driveway has been put on the property. While researching the property, I observed that there were no permits applied for or issued. A notice of violation was issued on March 7th, 2024. I have had contact with the property owner who stated that he had just cut the nuisance trees on the property. At the time of my corrective action inspection on March 22nd, 2024, no permit had been applied for and the limestone driveway remained on the property. As of my final inspection, there has still been no permit applied for or issued and the limestone driveway remains. My expert on the case is Ms. Joanna Catu from Land Development.
Ms. Catu?
Yeah, it's just a bit over 5 acres, as he discussed. Rural residential has power lines running right through it, is vacant, should stay vacant. They do have a mobile home that that Mr. Contos owns adjacent to it, but it is a separate parcel. So this is a vacant lot.
Gotcha. All right, thank you. What's the county I'm just curious, before I talk to them, what's the county requesting on this?
$5,000.
A fine?
Yes, a
okay.
one-time fine of $5,000.
All right, and is there anyone else who wants to speak from the public on this case, just so I know? All right. Well, now I would like to hear from y'all. So I think everything you said is relevant. So you're saying that, I mean, you actually own the adjacent property.
That's correct, sir.
Yeah. What's your intention with the property?
Well, first of all, I had moved from Sumter County with my parents, and we relocated to Citrus, and they live in Beverly Hills. So
Mhm.
what I was trying to initially do is I found out what I could do for structures there, not knowing I could not do anything else without a permit on vacant land, which was my fault. And I've been working with other mobile home people and things like that. So I was kind of picked Gainey, and then I got in this situation and had told them and this, and so I'm like up in the air now with really what I'm gonna do, because I'm also wondering if in fact I were able to combine both lots, and then it kind of would be one. That was an option. I'm not a developer or anything like that. I had plans to like do gardening and just make it nice. I mean, like where the Lime Rock was, they were cutting through with quads, and it was just disgusting. And I literally cleaned it up. I had people come and say, "Oh, it looks beautiful. Looks
It
beautiful."
doesn't look bad.
And
Yeah.
now I'm like, it just blew all the wind out of my sails, and I'm kind of at a standstill. So I really want to know where we are. And then I started doing some other like investigation on my own, due diligence, and I'm finding this and that. And I saw something here. It's I do have a couple pictures too that I'd like to show you on some of the trees that I did cut that were diseased and they had
I
holes
have
in
every
them.
confidence that that's accurate. I don't
Okay.
doubt you.
I just wanted to ask you, first of all, on if I combine both lots and put them on one deed, whether or not
That's a question for the county outside of the hearing.
Okay,
Because this isn't a case where I'm going to give you a time to comply.
okay,
The violation has occurred.
I-
There's no way to undo the violation.
I understand that. Well,
So they're requesting a fine.
Yes, sir.
And really the question is what the amount of the fine is going to be.
it seems kind of substantial to me, the fine. I mean, if I could mediate it in a different way and get it lowered and possibly put other trees in. I mean, I was talking to one of my other neighbors, and she was like, "What are you doing that day?" And I said, "Well," and she was very good. I mean, I put lime rock on her driveway where it was like, and I'm kind of wondering, like, I'm figuring maybe, I've been down to the county a couple times. One time when I put a berm up on my road, there were some neighbors that were talking, so I came in, I had met Miss Amy, and she directed me to another lady upstairs, and she said I could berm it, and, because I didn't want to start berming my road, my driveway on Chad Point, and having it flood everybody else, but that wasn't the case. Unrelated issue, there's a form here, it's Citrus County Tree Preservation Guidelines for Residential Property. This might not apply to me, but down below, there's an exceptions that say no permit required.
It's irrelevant,
Okay.
because what they're talking about is site modification
Okay.
without a development order. And it's a good point,
All right,
but what that really addresses is you having a piece of property and you taking a tree down, that you're allowed to take a tree down.
Yes, sir.
You know, there's some trees you can't just.
correct.
But that's not really the issue
All right,
here.
understood.
Yeah.
But could we also have it be known for the record that, and I had told, whoever I was speaking to, that I never received a certified letter, but it wasn't because, I guess because of the
Well, you're
property.
here, so I'm
Right.
gonna wait. I don't find that that's really
No,
relevant either.
but what I'm saying is I probably could have like alleviated all this to
I
come
see.
here if in fact, like the day I called you and I spoke to you, that rainy day was the day that it was brought to my attention. And if in fact it was previously, maybe we wouldn't be here. But what I would like to ask for you, sir, is if you could please reduce that monetary value, and if possible, I like trees, I'd rather
Mhm.
replant some things, or, I mean, I don't see where I took bad ones down.
Mr. Cinta, do you have anything you want to say, or you're here?
No, the fact that, sir, is that I've known this gentleman for a few years. I'm in real estate, and he's asked me a few questions about the property. And there are a lot of regulations and different things. I own a property myself, and then understanding that once you have the property, if you have a tree that's over the property of someone else, you're cut it down and stop it from falling on the fence. So for a little bit of discussion, he just mentioned that he wanted to stop some of the four-wheelers from coming in and out of the property and put the gravel down to kind of improve the property, not knowing that some of the turkey oak trees were on the property and leaning over. So without a lot of intent of misuse of his property, he's just not fully understanding, all the rules and regulations, and he's asking, the court here for a little leniency because he's trying to improve the property, bring his parents to the property and put maybe a large double wide so he could.
Did you say raise parrots?
Pardon me? Yeah, he's gonna get a.
Bring them,
Yeah, he's
relocate them.
responsible for his mother and father and his.
Oh, parents.
Yeah.
Okay, I thought you said parrots. That'd be the first for
Well,
Citrus
he's-
County,
Yeah,
probably.
yeah.
They've got some places in Miami for that, but.
Yeah, that's
anyways.
true. Yeah, that's true.
Okay.
So that's what his intention is, and then combining both properties would be, another issue. So he would have a particular property and, give his family a little bit of pleasure in having the whole family together. In no way, shape, or form, he was going to sell the trees or, misuse the property in any way. He's been.
It
a
doesn't
good-
look like it. I mean, I don't really,
Okay.
I think I'm pretty well persuaded of that. Yeah,
I would like to change my recommendation, my request to $1,000 fine.
I will find that a violation has occurred and assess a $1,000 fine. Okay? Instead of the original 5,000, the county, based on your presentation, the county substantially lowered its fine request, and so I think you persuaded everyone, and good luck.
Thank
That's
you.
it.
So,
I'll issue an order.
okay.
Yep, and it'll lay everything out.
And from here on,
You should contact the county and make sure everything you do is good. All right? Thanks.
I appreciate
Thank
it.
Next case on today's agenda, George R. Erickson, case number 2024-268, Code Officer Alan Jonason, page 9 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes.
Can you please state your name, sir?
George R. Erickson, Jr.
Thank you.
Good morning.
Good morning, sir.
Good morning.
Good morning. Alan Jonason, Citrus County Code Compliance Officer. This is case number 202400268. special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102. The address of the violation is 185 Northwest Avenue, Inverness, Florida. Property owner is Erickson George R. I have good service via posting the notice of hearing on the property and posting at the LeCanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 15 February 2024, photos from my compliance inspection on 18 March 2024, and photos from my final inspection conducted on 16 April 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
All right, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Is this the initial ones or is this from the photo you took yesterday? Let me see, check. Yeah, I'm trying my best. Okay?
Mr. Erickson, are you contesting that there's a violation?
No, to a point, yes.
Okay.
Just, it has to do with the structure. I have
Okay.
no place to live, and they're all legal hookups there.
Okay,
They're all approved. I just need extension if I'm to get rid of the RV.
thank you.
I need at least a month or two to find a place to move it.
All right, then let me hear what the county
I'm not
has.
contesting anything, but
Fair enough.
I'm
but-
trying to comply.
All right, fair enough. I'd like to hear, without objection, what's been proposed as Exhibits A and B are evidence.
Okay. On 15 February 2024, I conducted my initial inspection and observed the property to be in violation. On 15 February 2024, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance mentioned earlier. On 18 March 2024, I conducted my compliance inspection and observed that the property remained in violation. I've had contact with the property owner, and as of my final inspection on 16 April 2024, the property remains in violation. Expert on the case is Land Development Director Joanna Coutu.
Hello, so it's about 0.55 acres. Your MDRMH could allow a mobile home. We have no record of permits. It should be vacant.
Okay, thanks. Are you able to put a mobile home on there, or?
Yes, the hookups are there. There was a triple wide trailer on there. I just inherited the property 2 years ago,
Mm-hmm,
okay, from my mother.
mm-hmm,
And at the same time, the structure I lived in burned down. Okay, the structure. The structure that I did live in at 166 North Saturn was down. I had no place to move, limited income. I make less than $1,000 a month, Social Security, disability. And the only option I had to do was, I had an RV that I could put on there.
mm-hmm.
And I had a friend initially come there and look at, we inspected the tank. It was a 1,200 gallon tank, good for a big home with
Right.
2 bathrooms and fresh water, and the service is updated 200 amp service.
Well, so I mean, the issue here is you're gonna have to do one of two things.
Yes,
Either
sir.
you get that mobile home on there, or you have it be a vacant
Oh,
piece
okay.
of property.
Okay, I'm sorry. I did look for a place, like an RV place that I could put it, but it won't be until August 12th that I can move it. I called everybody, because it's a livable RV. I mean, it's updated and everything. I just need a little time to get rid of the RV and the rest of whatever debris might be there. And then I'll work on getting a permit to get the home there, the mobile.
Okay, so you're, if I'm reading between the lines, are you saying that you need basically like 4 months?
3 months would be fine.
All right.
I
Is there-
could comply with everything.
Is there anyone from the public who wants to be heard on this case? Yes. Why don't you come on up and,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Roy Ritchie?
Boyd Ritchie?
No, Roy, R-O-Y.
Thank you.
good morning, sir.
Good morning. I'm one of his neighbors. I was actually in here last month.
I remember.
Yeah, I was the one that asked for 10 years extension, but
That's right.
But I don't see a problem. He's almost 70 years old. I don't see a problem. He's a quiet neighbor with, and it's a mobile home community there, you know. And motorhome is technically a mobile home. What describes a mobile home is it's mobile. Okay, you know, he lives on less than $1,000 a month. You know, it's one thing going out to a guy my age, but he's 70 years old. You know, he's well, close to 70. You know, he's living on less than $1,000 a month, and you can't even rent a lot for $800-900 a month. You know, this man is doing everything he can to survive, and I would feel like, you know, if he could get a permit to put a mobile home there, why couldn't he get a permit to have his motorhome there? Because it's just him and his dog.
Well, the reason for that is this thing right here. There's a bunch of rules in there.
Yeah, well,
and-
he even has all legal hookups, septic, water, nothing's, you know, yeah, the property's overgrown.
Right.
Okay, you know, a lot of stuff, but there's people out in that neighborhood living in tents, and, you know, something like this could make him homeless. Okay, and, you know, I would not want to see this. He's a wonderful friend. You know, he's a good person. You know, I help him out whenever I can. He helps me out whenever he can. You know, and I just there has to be something that we could figure out to get him. His wife just passed away not too long ago. You know, so it's him and his dog, and less than $1,000. You know, he lost his wife's income and stuff like that. So, you know, now it's just, I would like the county to try to figure a way where we could keep his motorhome there, because it does have all the legal hookups.
Right.
And it's just, people are living in tents in the woods, and, you know, it's gonna make him end up having to do the same thing eventually, because, you know, you can't afford $800-900 a month just for a lot rent, you know, and I'm a concerned neighbor. Okay, yeah, I can understand cleaning up the property and stuff like that, but kicking the man out of the only home he has, you know, I really can't understand that, you know, and I do everything I can to help him on getting permits if it would be permittable to keep his motorhome there.
All right, thank you.
Thank you.
I believe there are other people from the public who want to be heard. Yep. If you want to come up.
You've never met me, but I've spoken to you on the phone. My name's Arcadio. I can actually.
Excuse me.
Yes.
I need to swear.
Oh, I'm sorry.
Do you swear to tell the truth, the whole truth, and nothing but the truth? So
I
help you
do.
God? And your name, please.
My name's Arcadio Morales.
Thank you, sir.
So this man's called my business before, which we'll get to later. And he actually, I could vouch for him trying to move his RV. He called us and he asked if he could park his RV at our location long term, and I told him no, because we don't allow for people to stay at our property long term, let alone RVs. So that's what I can say. I'm from Happy Campers Rescue Ranch. You called me, and I remembered his voice
He's
right
trying.
away.
He's
And
trying.
she told me too. She's like, I know it is him, and I'm like, I gotta go there. I gotta vouch for him.
I appreciate that.
Yeah. So
Yeah.
he is trying.
Yep.
For
Thank you.
whatever that's worth.
It's worth something. Thank you. Is there anyone else from the public who wants to be heard? What's the county's recommendation on this?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. You've asked for 90 days.
Yes, sir.
I'm going to grant you 90 days.
I appreciate
And
that
if it's
very
not brought into compliance within that time, though.
Yes, sir.
Okay, there's going to be that
It's
$50 a day
understood.
fine. But good luck.
Okay. Thank you.
All right.
Thank you.
I know.
Alan.
Thanks.
Next case on the day's agenda, Edward A. and Erica Jules Furlong, Case number 2024-147, Code Officer Brandon Norman, page 10 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please, sir?
Edward Furlong.
Thank you.
Good morning.
Good morning.
How you doing?
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2024-00147, special requirements for all accessory structures, a violation of Citrus County Land Development Code, section 3102, subsection A. The address is 4336 East McCartney Loop, Inverness, Florida. Property owner listed as Edward A. Furlong and Erica Jules. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on February 2nd, 2024, the corrective action inspection done March 11th, 2024, and my final inspection done yesterday, April 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
No, I didn't get the original, when I first got this letter or something, because I didn't pick it up at the post office.
Okay.
But other than that, no.
Is there anyone from the public who wants to be heard on this case? All right, I see and hear no response. All right, thank you. Without any evidentiary objection, I'll admit exhibits A and B as evidence. Go ahead.
On February 2nd, 2024, an initial inspection was conducted for the property for storage on a vacant parcel. I observed a utility building, construction materials, RVs, and other personal effects. The property was found to be in violation that day. The property showed some change but remained in violation at my notice of violation corrective action date on March 11th, 2024, as well as my pre-hearing inspection conducted yesterday, April 16th, 2024. I have had contact with the property owner. They're aware of the violation and how to come into compliance, and I have an expert for the case.
Okay.
And this site is 0.22 acres, very small, rural residential, mobile homes allowed. It should be vacant. It looks like there probably was a mobile there in the late 90s. Sometime between then and now it was removed, but the accessory structure was not.
Okay, so even, I mean, that's the big, I guess, violation here is that accessory structure.
Right.
I mean, there's other little
It
bits.
clearly was placed a long time ago, but
Right.
it went sometime, the mobile home didn't get any kind of demo permit or anything. I don't know when it came off, but
Okay.
when that came off, that should have as well.
All right, I understand the county's case. Does this make sense to you?
Well, no, I bought the property on a tax deed auction in December. I had,
December of 2023?
yes.
Wow.
I had meth heads living there. That's why all the campers and stuff there. There was a mobile home there 3 years ago, but they blew it up, making meth. But, so I bought the property next door to that one and was interested in this property they're talking about now. And I just, you know, it had that building that they want, which was recognized in 1980. It was built in 1961 without, I don't know. But I did talk to the daughter of the two owners, the dad and the grandfather. But anyway, now it's pretty much cleaned up. I'm trying to save that block house.
Mm-hmm.
I've been trying to cooperate, and I've called the permit place. They said I could get a remodel permit, or I can get I can go through surveying the land and then get a structural engineer, people out there to inspect that little building, because it used to be a.
That's not really the issue before me today. The issue before me is that structure exists, whatever its shape, but there's no principal structure on the property. In other words, it needs a home. Am I wrong? I mean,
No,
Yeah,
you're
so-
correct. I think what he's trying to say is that he's looking to get that turned into the principal structure.
Oh, I see. So you're trying to turn that into the
Yeah,
principal
because it's
structure.
been
I
there
see.
since 1961.
Okay.
I can't
And-
confirm
and-
that. I'm sorry, go ahead.
And there was a double-wide mobile home on it until they blew it up, like I
Right.
said.
Right.
But there was another shed on there that they stole, you know? So I'm just trying to keep that structure even if I make it a shed. I mean,
I don't
got
think
well-
making it a shed is gonna be enough, but if you make it into the principal structure, that would be enough to abate the
Right.
violation.
Well, that's what I'm trying to do.
Okay.
And, I'm not sure exactly how to go about it because like I said, they said, remodel permit. Or something else, I talked to Brandon about it. What was that other one?
There's options.
He does have options, and I can confirm that he has been in contact with the building division. They've come over directly and spoken to me. We've spoken in great detail about the case. I don't know what their interaction has been on that, but I know that he has been exploring options to come into compliance.
I'm trying.
Yeah.
'Cause I really don't want to tear that building down. I mean, it's a
first
decent
one-
building. Like
Is
I
there
said,
anyone from the public who wants to be heard on this case? Just curious. Okay, I don't see or hear any response. Well, look, the county's brought this case, so they're asking me to put your feet to the fire, and the question is, how much time do you think you need? Whatever the options are, you know?
Right.
It sounds like you could possibly salvage this. You might, there's other options too. How much time do you think you would need?
I'm not exactly sure what I need to do
I don't
to
know
do it.
either, yeah.
I do have one more thing to add as well. During the course of my inspections, I can agree that he has had some unwanted visitors there, and they've done things such as burn large piles of trash and debris there, so much so that I had to call the fire department on my corrective action inspection date.
Wow.
Yeah.
Um,
I mean, they're a big nuisance to that area that's in there.
Yeah, that's a bad area.
Yeah.
I'm trying to clean it up. I just bought the one next door to that one too.
So while I have the storage on the vacant concern, the other concern too is getting the violation corrected in order to hopefully mitigate the nuisance that is.
Are
occurring
landmines a violation of the land development code, or?
But for the most part, it's cleaned up.
No, it has.
It looks a lot
it's made
better
some
even in the
drastic improvement,
photos
yeah.
from the
Yeah.
first
Yeah.
time. But look, I have to, there is a violation, so the only question for my purpose today is how much time I'm gonna give you. Now, normally in a situation like this, I would give 60 to 90 days. But I don't know, I mean, if you're gonna salvage that structure, would the issuance of a permit abate it if they were converting it? Or I think it has to be established. I think the principal use
From
has
my
to be
understanding, it has to be
established.
established as a principal
Yeah.
use, so it would need a CO at the end of the day.
And that's gonna be tough.
Yeah. I definitely think it's gonna be a process, so. Because I'm not even sure what the inside
Okay.
of the structure looks like at all.
All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs beginning after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation and is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master to find its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection. And the $100 is just because of the concern for the.
I mean, this is the problem with, tax deeds, or stuff. It's like you take it as it is,
Right, but
essentially.
see, I didn't know it was considered a vacant land because there was a mobile home on it.
Yeah.
And then it had the two structures on it.
No, I know.
And then I asked if I put another mobile home on it, would the building be okay? And they're like, no, because it's not permitted. I want to permit the building. That's what I'm trying to do, permit that building. I just don't know a way to do it.
All right.
Because I've never been through it.
I'm gonna give 5 months, and if it's not brought into compliance after 5 months, it'll be $100 a day. Okay?
Okay.
Good luck.
Thank you.
Next case on the day's agenda, Johnny A. Gray, case number 2024-253, Code Officer Julie Wilkinson, page 12 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400253, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 2349 South Stanley Terrace, Homosassa, Florida. Property owner is Johnny A. Gray. I have good service via sign
Did you say what was the address you gave?
2349.
Oh, okay, gotcha.
I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 13th, 2024. Photos taken during a corrective action inspection on March 13th, 2024. And photos of my final inspection conducted on April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, is there anyone from the public who wants to be heard on this case? All right, neither hear nor see any response. Without objection, what's been proposed as Exhibits A and B are evidence. Okay.
On February 13th, 2024, I conducted an initial inspection and observed a Jeep and RV and construction equipment and a pile of rock on the property. On February 13th, 2024, a notice of violation was issued for special requirements for accessory uses, which is a violation of the Land Development Code. On March 13th, 2024, a corrective action inspection was conducted, and there were more items being stored on the property. It was a whole campsite. As I have had contact with Mr. Gray, who has told me that he will be applying for a permit to build and request to use the RV while building. As of my final inspection on April 16, 2024, the property remains in violation. My expert on the case is Land Development Director, Ms. Joanna Katu.
This is about 0.22 acres. They do have 5 adjacent lots, but they're also all vacant.
The same owner has 5
Same
adjacent?
owner has
Wow.
5 adjacent, but they're all vacant. We have no applications as of this morning.
Do you know if someone is allowed to stay? I mean, is it possible that they could stay in an RV while they construct?
Yeah, there is a provision you can ask for as part of your permit to allow you to reside in an RV on site, one RV.
Interesting.
But
So,
they-
so it's possible that it abates at the time a permit's issued?
If the RV was the only thing, but they
Yeah.
also,
It's
they've done some clearing and
No,
filling.
I get it.
Yeah.
Okay, thank you. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
Just so we're on the same page, what else is on there that is a violation? Like the pile of pebbles or?
So he has removed everything except for there's a wood burning stove.
Okay.
Um,
And the RV?
The RV is gone. He
Oh,
left, according to a neighbor, he left on Friday.
Okay.
I don't know if he's gonna show back up or not.
Mhm.
Time will tell, but I have more cases for this same property coming next month, so we'll see.
We'll see.
Yes.
Maybe they abate. All right. The recommendation was?
$150 a day.
Okay, then I'll find that a violation has occurred, grant 30 days from today to abate the violation. If it's not brought into compliance as ordered, $150 a day.
Thank you.
Thanks.
Next case on our agenda, Paula Molina, case number 2024-221, Code Officer Cody McGuire, page 23 of your agenda. Expert on the case, Joanna Katu, Land Development Director.
Good morning.
Good morning.
I'm just gonna wait for the code officer.
He's trying. He's flipping through pages.
truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Your name?
Paula Molina.
Thank you.
Good morning.
Good morning.
Good morning.
Cody McGuire, Citrus County Co-Compliance Officer. Case number 2400221, a violation of Citrus County Land Development Code Section 4002, site development without a development order. Address is 9689 West Cherokee Lane, Chris River, Florida. Property owner is Paula Molina. Good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 13th, and photos of my corrective action inspection on March 15th, and a pre-hearing inspection on April 16th. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the general pre-hearing order, a notice of the hearing posted on the property, and a posting affidavit.
All right, ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
No
Okay,
objection.
all right. And is there anyone from the public who wants to be heard on this case? I see no response. Ma'am, are y'all contesting that a violation has occurred? Are you arguing that a violation has not occurred?
Ah, it's fine.
Okay,
Yeah,
all right.
it's fine.
You agree that there is a problem?
Yes, I apologize for the fault I committed.
Okay, it's
I
no problem.
just-
All right. Then let me hear what the actual problem is, and then we'll get to you.
Okay. I conducted my initial inspection on February 13th and observed the property had trees removed and grade work after. While researching the property, I observed that there was no permits applied for or issued. I have had contact with the property owner, just communicating through voicemails, and as of April 16th, 2024, there were no permits applied for.
What did they do?
There was site modification.
What did they do?
There was trees removed and the ground was cleared. Or leveled.
How do you know?
From pictures from the pictometry.
Pictometry?
No, I don't have it in there.
You may, I mean,
Mr. McGuire, what is pictometry?
It's a photo from an aerial view from the Citrus County Property Appraiser's website.
And what does that image depict?
It depicts everything that is above that property.
And
So
were
what?
there trees on that property at the time of that depiction?
Yes.
When was that picture taken?
The pictometry picture? I believe there's a date on it. I have it back here.
If you could please go get it.
You might want to get it. Ms. Molina, I want to make sure, do you understand everything that's being said? You do?
Yes.
And
I
sir, who are you?
understand. Yes.
Sir?
Oh, no, I'm a friend from him.
Oh, you're a friend, okay.
I have 3 lots behind me.
Ah, okay. Did you want to be heard on this case as well?
Yeah, it's the same
Okay.
case.
Okay.
4 lots are together.
Okay, all right.
He has another case.
Oh, I see, okay.
Actually, 3 other cases.
Okay.
It's the same place.
It's the same place, okay.
4 lots together.
Okay, all right. But Ms. Molina, I just want to make sure that in terms of language, that there's no problem.
No problem. It's good. It's fine.
Okay.
I understand.
Entiendes?
Yes, I
Okay.
understand everything. Yes.
Okay.
Show it to her.
Okay. So here would be the 4 lots that we were looking at.
Let me see.
Look, I don't know if I want to belabor this, y'all. I mean, it sounds like there were trees and now there aren't trees and,
I'm sorry.
okay.
Can I swear you in? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And your name, please? Yes. Thank you.
Thank you. And so which lot on here?
We'll be doing these four right here.
Which one is this one?
The address was
9689. Okay, all right, thank you. Are you seeking to admit this into evidence? All right, this will be Exhibit C. I think I understand the county's case, so tell me, what, did y'all take down, did you take down trees?
I honestly didn't know I was doing anything wrong.
Right.
And I thought I only need a permit to build the house.
Mm-hmm. Yep, that makes sense. You're not the only one. So what's the county's recommendation?
Due to the irreversible nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $2,500 along with administrative costs. This amount was selected based on the actions of the property owners once they were advised of the violation.
Do you have any mitigating circumstances you'd like me to take into consideration as to why the fine should be lower or higher? That'd be an aggravating circumstance, I guess. Does that make sense?
We are going to do the permit for that lot.
Oh, I know.
Yeah.
Yeah,
No?
for sure.
Yeah.
But, so we had a case earlier today where a very similar violation occurred. And in that case, based on the circumstances, I did assess a fine. And I have to assess a fine here because that's what the law requires. There's a penalty when you do something without permission. And part of the reason is that there has to be a deterrent value to people going out and clearing the sites without a permit. So I will assess a fine. The only question is the amount. So is there anything else that you want me to know about the lot or your circumstances before making a ruling in the case?
No.
Okay.
Maybe vote.
Oh.
Yeah.
So I think I understand the request. And so on what basis?
How much?
What they've asked for a $2,500 fine. So what would be the reason to lower it from what they've requested?
Okay.
What is the reason?
The reason.
Why should I? Okay. Then what I'm going to do is I am going to find that there is a violation on the property. Historically, that is the amount that I have given on these fines. So I'm going to, unfortunately, I'm going to issue that fine, $2,500. All right.
I think that's a little ridiculous, it's just, they don't even understand.
I'm sorry. Actually, did I ask for the public? Do you want to be heard? Did I ask for public input?
I don't think you did on this one.
Okay, I think I did, but I didn't get any response.
They don't understand. They don't even understand what you're saying.
They said they wanted to proceed.
Yeah, but they don't understand that when you're asking them.
I can't tell, that's why I have to ask.
That's so messed up.
Yeah.
Y'all are so messed up.
May I help you, honey? Translation?
Yes, please.
Because they didn't understand, my language is Spanish as well.
I'm not sure. I can't tell if they understood or not, to be honest with you.
250.
No.
No, sorry. What do you say again? Sorry, the amount.
Well, look, here's the deal. That we're noticed for a hearing today. Does that make sense? You're here at a hearing. And so you've got to have, you told me you understood. Do you remember?
Yes.
Okay. So, and sir, you're not even the defendant here. Miss Molina, you're the person who's really here. You're the one who needs to understand.
And can you help me with something less? Because in this moment, I don't have plans to develop the land.
Yes.
I just.
So you do
clean
understand what I'm saying. ¿Entiendes mis palabras?
Sí.
Okay.
Entiendo.
So, Normally, what they do is they'll request, and they have done this, $5,000 fines, and I reduce it to $2,500. So they know that what I usually do is $2,500 fines on these cases. Because that's consistent with other fines that I've issued in other cases, that's what I'm doing here.
2,500.
Correct.
One time.
Yeah, it's a one-time fine. It's
One
it's
time.
it's a one-time fine.
Eso es 2,500.
20, sorry, can you repeat the number?
2,500 is
2,000.
2,500.
Yeah.
And can you help me with something?
I did. I mean, that's my reduced fine, essentially. Normally, the request is for 5,000. This is for 2,500. I'll issue an order. I don't think they're going to foreclose on you, but that's going to be the fine. Okay? This hearing is closed. Next hearing.
One thing, we don't do the remove the trees. We bought the lot.
Sir, I don't even know if your case is up yet. When your case is called, I definitely want to hear from you. You have an opportunity, and I want to hear from you.
The next case on the agenda, Randall Scott Heward and Melissa Dawn Heward. Case number 2400358. Code Officer Julie Wilkinson, page 13 of your agenda. It scared me, it got up there so fast. Sorry, apologize. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Melissa Heward.
Thank you.
Good morning.
Good morning.
Okay. Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400358. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6524 West Acasian Lane in Homosassa, Florida. Property owner is Randolph Scott and Melissa Dawn Heward. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on March 1st, 2024, corrective action inspection on March 18th, 2024, and photos from my final inspection conducted on April 16th, 2024. Exhibit B, a copy of the notice violation, a copy of the notice of hearing, and a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing. Okay. Are you contesting that a violation has occurred?
No, sir.
Okay. How much time do you need to fix it?
Like 60 days. I've cleaned up most of it. I just got to get the rest of it done. I'm separated from my husband. He no longer owns the property, so I'm sole owner, and I have 3 kids. I got a job. I'm just trying to.
Well, what I want to make sure is that 60 days would be enough. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative costs beginning after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for
Is there
reinspection.
anyone from the public who wants to be heard on this case? Are you sure 60 days is enough? I mean, do you think it, I mean, I don't know. It looks, has there been improvement? There has been improvement.
Slight
Slight.
improvement.
So basically, everything that I see in the photos is mostly still there?
Yes, sir.
Okay, I'm gonna find that a violation has occurred, give you 90 days, $150 if it's not brought into compliance as ordered.
That's fine.
Okay, good luck.
Thank you.
And this was admitted into evidence.
Next case on today's agenda, Michael J. and Laura J. Kreiner, case number 2023-695, Code Officer Julie Wilkinson. Page 18 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
And your name, please?
Mike Kreiner.
Thank you.
Good morning.
Julie Lyons Officer, case number 2300695. Special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 11342 South Turkey Foot Point, Homosassa, Florida. Property owner is Michael H. and Laura J. Kreiner. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on August 14th, 2023. Photos taken during a corrective action inspection on March 6th, 2024. And photos of my final inspection conducted on April 16th, 2024. Exhibit B, a copy of the notice violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Howdy. No.
Okay. Is there anyone from the public who wants to be heard on this case? Okay. Without objection, what's been proposed as exhibits A and B are evidence. Go ahead.
On August 14th, 2023, I conducted an initial inspection and observed a semi-trailer and a vacant mobile on the property. On August 16th, 2023, a notice violation was issued for special requirements for accessory uses, which is a violation of the Land Development Code. On March 6th, 2024, a corrective action inspection was conducted and the semi-trailer was still on the property as well as the RV, cargo trailer, and other items on the property. I have had contact with Mr. Kreiner, who has been very kind and friendly. As of my final inspection on April 16th, the property remains in violation, although he has had the mobile removed. My expert on this case is Land Development Director, Ms. Joanna Coutu.
It's 0.6 acres in size. It's Coastal Lakes residential mobile home allowed. One concern about this one is our wetlands layer shows it almost or entirely wetlands. Even the plat says Cypress Pond area. So there might be some difficulty in obtaining a permit to establish a residence. There's going to be a lot of hoops to go through first.
Okay, thank you. Does that make sense?
What was the land area?
It said 0.66-ish.
0.68 acres, 0.68 acres.
What's the address of that one?
This is the
Are there
one,
multiple?
11342.
11342, that should be 8.99
I
acres.
think you're combining lots. Okay.
No. There's 11370. Is that case closed?
That case is
technically?
closed. We're only talking about the property where you had the
The
semi-trailer.
trailer,
Mhm.
that should be 8.99 acres. But I bartered a friend, he was supposed to show up Monday with equipment to pull that trailer from where it is. I was gonna turn it into a fish farm and a hydroponics garden, but because it's on wheels, I can move it. And that's the intention. He broke down Monday on the way. When she showed up Tuesday, I actually requested she did, because I planned on them both being on the road, ready to get off the property when she was there, and this would all be done.
Then how much time do you need?
Well, Methlicans are a little unreliable.
Who?
Methlicans.
Oh,
And,
I've never heard that term before.
Well, it's a Citrus County thing, I think. I would like to see it done in 30 days, but because I bartered, because cash is limited, I am kind of at the mercy of him unless, no, could I possibly get 60 days?
I mean, it sounds like you already had it taken care of. I mean, it
All he has to do is pull them out and pick
Right.
up my car. I traded
Yeah.
a 1957 Ford Fairlane 500 for the barter. And I traded a lot of other stuff for, I mean, I scrapped 22,000 pounds worth of steel. I've been a citizen of Citrus County since 2001. I've had a trucking company in Citrus County for almost 20 years until September 11, 2015, when an illegal crashed into my truck. I closed my company. I started a printing company in 2016. COVID took me out. So my original violation was my shop from Cortez Boulevard in Brooksville was in a pile behind my house, which I scrapped since then, and this trailer that I'm currently
Well, what I'm trying to get at is, I mean.
It will be gone in 30 days.
Yeah,
Give me
that's
30
what
days and I got you.
All right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of property owners once they were advised of the violation. We would also ask the special master additionally to find that it is a respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'm just going to ask, maybe again if I missed it, is there anyone from the public who wants to be heard on this case? All right, then I'll grant 30 days, was it 100?
$50.
50, so $50 fine if it's not brought into compliance as ordered per day. Thank you.
It'll be done.
All right.
Next case on the day's agenda, PYP 2024-219, Code Officer Cody McGuire. Page 29 of your agenda, expert on the case, Joanna Coutu.
I'm just gonna swear you in again, because I need you to say your name slower.
Okay,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Thank you. And your name?
Larry Gomez,
Larry Gomez?
Yes.
Thank you.
And so we're only bringing this one, the first case? Yes, sir. Okay. So you have three, but we're going to deal with the first one first.
Okay.
Okay. Go ahead.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 2400219, a violation of Citrus County Land Development Code Section 4002, site development without a development order. Address is 9712 West Hayes Lane, Christian River, Florida. Property owner is PYP. Goods service via signed certified mail receipt and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 13th, photos from my corrective action inspection on March 15th, 2024, and a pre-hearing inspection on April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, now first I want to ask, there are three cases here, but this one's listed under PYP. The other two are PYP USA LLC. There are two different entities?
No, it's the same company.
So all three are PYP USA?
Yes, sir.
Okay. And you're an owner or officer of?
Manager.
Okay, sounds good. Now, I'd like to ask you to take a look at these documents and let me know if you have any objections to them. And by the way, as I said at the last hearing, if you have any questions about what you're hearing or not hearing, please let me know.
Okay, sir.
Make sense?
Yes.
¿Entiendes mis palabras? Okay. No objections?
No, for the photo.
Thank you. Then, without objection, what has been proposed as Exhibits A and B are evidence. Go ahead.
Okay. I conducted my initial inspection on February 13th, 2024, and observed the property had trees removed and grade work after. While researching the property, I observed that there were no permits applied for or issued. I've had no contact with the property owner. As of April 16th, 2024, no permits have been applied for.
You've had no contact with the property owner?
Per this address.
Okay. In other words, with Mr. Gomez, you have not had contact?
No, sir.
Okay. All right. So what's going on?
We bought one lot in November 22. After I bought the lot, somebody asked me if I want to clean. I said, okay. I didn't know I can clean the lot. In other counties, I can clean before the permit, and later you obtain the permit. Later, we bought the two lots, but they was clean now for me.
Right.
I just cleaned the first lot. The second and the third lot, I bought the lots in February 23.
Mm-hmm. Well, now we're only here on. We're only going to talk for this purpose about 9712 West Haynes or West Hayes.
Okay,
so
yeah.
On that lot, I want to make sure I understand what you're saying. On two, we're not getting into all of them, but on 2 out of the 3, they were already cleared when you bought them?
Yes, sir.
Okay. Is this one of the properties that was cleared before you got it?
No, I cleaned that.
This is the one that you did clear?
Yes, sir.
Okay. Let me just ask the county, I'm curious, if they did not, if PYP didn't do the clearing, are they still responsible from your perspective? I know we're not there yet, but this helps me determine what a fine should be, okay?
I'm gonna look to our attorneys here for a second.
One moment.
Okay.
The county's position is that you get the property as you purchase it. Had there been a shed on it when you bought it, and there's no primary residence, you still are responsible for the property as you take it. So you have to fix the violation that occurs. So in this case, even if the violation occurred before he purchased it, he takes the property as he purchases it, and he has to fix what's wrong with it.
But there's nothing to fix, it's a one-time thing, and they're asking for a one-time fine. Normally I would agree.
Well, he can fix it. He could put a home on it. He could have, when he purchased the property, got a permit, and he could put a home on it.
On this property, yeah, but take the other ones where he basically bought it, it had already been cleared. There's nothing he can do about that. That's according to the county, it's, what's the word?
Irreparable?
Irreparable.
Yeah.
So I guess what I'm trying to understand is why, if he was blameless for the guilty act, he should be responsible for
One thing.
the.
One little thing.
Oh,
Sorry.
okay.
Now I paying for the permit. I contact a general contractor. I doing the survey. I pay for the designs, and he's doing that for I don't know, obtain the permit now. In this moment.
I know.
Yeah, 2 months before I start with that. The survey was in February. The design the pay for the design is here. I doing the things, the correct thing.
I mean, it says in section 19-24, it defines violator, and it says, violator shall mean the person creating or permitting the violation, or a person who owns, controls, or is otherwise responsible for the real property upon which the violation occurred. Looking at it from if I liberally construe that and read it the way Justice Sotomayor wants me to read it, then I guess I agree with the county. My concern is that how do you punish an arm's length purchaser for a violation that someone else did? Because it sounds like you could go after the person under this code section who really is responsible. Okay, well anyways, I understand. Yeah, go ahead.
Okay, just if I may, we can't create two separate standards off of one definition. So if Your Honor is inclined to say that we can't hold him responsible, then anybody who buys property that has a violation on it can make that same argument before Your Honor, and you set the precedent that buying property with a violation means you don't have to fix the violation. And in this case, fixing the violation would be permitting a house, getting this, what he's doing, getting all the engineering drawings and getting everything done to appropriately permit and put a residence on home. He's doing that.
But it doesn't fix the violation. It's a one-time violation that occurs regardless of what he does. And so that's what I'm distinguishing for the county and what I'm seeking guidance on, is that it's not a case where the previous owner let the grass grow over 18 inches and it's still over 18 inches. He could fix that. I get that. And I think that would be why the expansive definition would apply. But in a case where it's a one-time violation and y'all could go after the person who's responsible, but it's not this person, why should they have to pay the one-time fine for, I guess that's what I'm agonizing over, because it can't be fixed.
Well, it can by getting the permit. So this is honestly the county being nice. So what we did do historically was, if you purchased this property and it was cleared, you had to put a house on you had to put a primary structure on the property. And we came before Your Honor and we asked for a $50 fine if you didn't. That resulted in individuals who purchased cleared property having $300,000, $400,000 fines accumulating because they never intended to put a primary purchase on there, and they inherited the problem.
Correct.
So the county being nice, we were like, okay, we understand people inherit problems. We're going to do a one-time fine so that doesn't have a purchaser end up with a $300,000, $400,000 fine when they never intended.
I see where the county's coming
So
from.
we're trying to be nice here and give them a one-time fine and have them wash their hands of it, or they have to put a primary structure on it. We give them a daily fine. And
Have you ever seen Doctor Strange in the Multiverse of Madness? There's a scene in there where the Scarlet Witch is about to destroy everybody, and she goes, "This is me being nice."
I actually have seen that movie.
Okay,
so yes.
yeah. At any rate, do you understand where I'm coming from?
I completely understand where you're coming from. We just can't have a double standard. The code
I
is
will
the
not
code.
have a double standard. I can assure you that there won't be a double standard here. On this one, it's uncontested. So, you had it cleared. What's the county's recommendation on this case?
Due to the irreversible nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assesses a one-time fine of $2,500.
So there's two other cases here, and we're going to open up and have a separate hearing for them. But is it the same essential case? Okay.
Yes.
Mr. Gomez, did you know who cleared the other two when you had this one cleared? Like, did you hire the same person?
I don't know. I think
You don't know?
no.
Okay. What I'm going to do...
Can I have some time, maybe 1 month, to have the permit? And I don't know.
That's not what they're asking. So what they're asking is that there be a one-time fine and it's over and done with. It's not something that can be fixed, whether you get the permit or not, for this actual case. But I am aware that there are two other cases. And so what I'm going to do is I'm going to find that a violation has occurred and assess a fine of $1,000. Okay? And we'll hear what happens in the other cases. Okay?
Yes, sir.
Next case, PYP USA LLC, case number 2024-218, Code Officer Cody McGuire, page 30 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Are you ready?
Yes, sir.
Okay.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 24-218, a violation of Citrus County Land Development Code, section 4002, site development without a development order. Address is 9680 West Hayes Lane, Crush River, Florida. Property owners PYP USA LLC. Goods service via signed certified mail return receipt and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 13th, 2024. photos of my corrective action inspection on March 15th, 2024, and a pre-hearing inspection on April 16th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, copy of the signed certified mail receipt, and that's it.
Sir, same deal. Ask if you can look at these documents and let me know if you have any objection to them being evidence.
Oh, the same picture now.
Okay, I mean, it's going to be different photos because it's a different property, and we're trying to go through the motions to make sure you have due process. You have the opportunity to object if you need. And if there's members of the public who want to be heard, they can be heard. Okay. Is there anyone from the public who does want to be heard on this case? Okay. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence. Mr. McGuire, go ahead.
Okay. I conducted my initial inspection on February 13th, 2024, and observed that the property had trees removed and grade work. After a while researching the property, I observed that there were no permits applied for or issued. I have had contact with the property owner, stated that she had received my notice of hearing, and they were planning on pulling a permit in the middle of July because changes had been made to the plans and had not been approved yet. As of April 16th, 2024, no permits have been applied for.
Wait, so this is which property? 9701 West Cherokee?
9690.
9690 West Hayes, okay. And you did have contact with the property owner?
It was a voicemail.
Oh, wait, oh, they left a voicemail for you. Who was the owner?
They didn't state.
The same.
It was, who
That
was?
lot, 9690? Yes.
Yes.
Yeah, it's the same.
Oh, you left a voicemail?
No,
Do you know who did leave a voicemail for
I
him?
don't know. What number you have?
I don't have it with me.
When did you acquire the property?
February 23.
Okay, a little over a year ago.
That property is clean when I bought that. This is the same.
But you said you got a voicemail about a pool? Did I mishear something?
No, not a pull. It was a voicemail about a permit being pulled.
Oh, a permit being pulled.
Mm-hmm.
But it was from a woman?
Mm-hmm.
Did they leave a name?
No name, no number. It was in regards to this address.
Do you know who might have left him a voicemail, like a woman, on
No.
behalf of PYP USA?
I don't know. Sorry.
Okay, there could be someone out there. I don't know. But same basic deal, essentially. And this is a property where you did not authorize the clearing. You purchased it, and it had already been cleared.
Yes, sir. I swear that.
Okay. Well, you've heard the county's interpretation of the code section. And I think part of the reason is that if someone clears a property and then sells it to another entity that they control, that might be a way of escaping the fine, okay? So in the end, the code provides that you take the property as it is, and sometimes when you buy a property, you can, if someone leaves a problem for you, you can sue them for it. Now, I'm not your lawyer or anything like that. I encourage you to seek legal counsel. But I think that's the regulatory structure that's been set up. It's not uncommon. What's the county's recommendation?
Due to the irreversible nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assesses a one-time fine of $2,500.
So what I'm going to do is find a violation and assess a fine of $750. And you can probably see where I'm going with this.
Yes, sir.
Okay. Does that make sense?
Yeah. Can you repeat the amount, please?
I'm sorry?
Can you repeat the amount?
Yes. The 750.
Okay.
So the last case was 1,000. This is going to be 750.
Okay.
And if the evidence is what I expect it to be on the next case, it'll also be 750 for a total of 2,500, even though it's 3 lots, because it's similar to the last Miss Molina's case, for example. So I'm trying to kind of come to the same result, if that makes sense. But we'll get to that case, so we'll see.
Okay.
What's the next case?
Next case, PYP USA LLC, case number 2024-220, Code Officer Cody McGuire, page 31 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Go ahead.
All right, Cody McGuire, Citrus County Code Compliance Officer. Case number 24220, a violation of Citrus County Land Development Code, Section 4002, site development without a development order. Address is 9701 West Cherokee Lane, Chris River, Florida. Property owners PYP USA LLC. Goods service via signed certified mail receipt and posting of the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 13th, 2024. Photos of my corrective action inspection on March 15th, 2024, and a pre-hearing inspection on April 16th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Same case.
Okay. Okay.
Oh, no, it's clear. Understand.
All right, without objection, what's been proposed as Exhibits A and B are evidence. What's the county's recommendation? It's the same?
Yes, sir.
Meaning you're recommending a fine of $2,500?
Yes, sir.
Okay. And it's the county's case that this is essentially site clearing without a permit?
Correct.
Do you have anything else that you want to add?
No, sir.
Okay. Again, I'm going to find that actually, is there anyone from the public who wants to be heard? Okay, I'm going to find a violation, assess a fine of $750. That's it.
In this lot, I'm doing the permit. Maybe can I have 2 months, 1 month? No, it's possible.
It's a one-time fine. This is the way these cases are presented.
Okay.
And when you watch on YouTube, as so many of our other viewers do, you'll see that it's basically a $2,500 fine most of the time. Yeah. Good luck.
Thank you.
Thank you.
Next case on today's agenda
Well,
is
last thing, can you repeat the amount for the first case? 1,000?
For the first case was
Okay.
1,000.
Is the same case for my friend? No, it's different case.
It's
The
a different
amount.
case.
Okay.
So you have 3 cases. The
No,
fines
but
were
the 4 case.
Miss Molina's case. That was 2,500, and yours add up to 2,500.
Okay.
Okay. Thank you.
next case, Scott E. Schiller Jr., case number 2024-266, Code Officer Julie Wilkinson, page 32 of your agenda.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Your name?
Scott Schiller.
Thank you.
Mr. Schiller, do you contest that a violation has occurred on your property?
I don't live there.
Okay.
I don't have a clue really what's going on.
You don't know? Okay.
Unfortunately, I've had minimum communication even after I stated to communicate with me, not the tenants.
Well, so you'll learn things today.
So
Okay.
unfortunately, I don't know, and I'm not a lawyer. I'm very uncomfortable not having one with me. I've tried to call. Unfortunately, Citrus County is very limited on lawyers that represent here. So you guys have a lawyer, which puts me at a huge disadvantage. So we're going to see where this goes and see what I need to do or don't need to do moving forward.
Okay. Present your case.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2400266, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4929 South Grand Circle Terrace, Homosassa, Florida. Property owner is Scott E. Schiller Jr. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 15th, 2024, a corrective action inspection on March 6th, 2024, and photos of my final inspection conducted on April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Let me ask you, Ms. Wilkinson, before we get to presenting evidence, do you
Yes,
have
sir.
any immediate health, safety, sanitary concerns on this case? I haven't seen the photos, so I don't know. Are there some, like, any, like, human waste or anything like that?
No, sir.
Is it what you would characterize as maybe a standard junk case?
Yes.
Why do you hesitate?
Well, I can't observe the entire property, so I am unaware of what is possibly.
Are you aware
lurking
of
in the
any
back.
vermin?
No.
Okay. So, Mr. Schiller, I guess what I would ask you is, before having you review these documents and letting me know if you have any objections to them being evidence, are you asking for a continuance so that you can hire an attorney?
I tried. I called the board or whatever, where everybody said, because I called I even called your office and they said, nope.
Mine?
Yeah.
Really?
I called everybody. They're like, nope, he's the guy for the here, so we can't represent you. Call these people.
Okay.
I called those people. Apparently there's only 2 in this county and they're retiring. They're not taking new clients. So I called the lawyer board, whatever. Everybody that they sent me to said, we don't represent Citrus County. I can't find a lawyer. I would love to have one because I'm not one.
We do have them up here, usually, I don't know, every other hearing we'll get 1 or 2. It's usually the same folks.
Because at the end of the day, I don't live there, and I have to abide by the other courts because it's my mother. My mother lives there, but they're still technically tenants. So I can't just roll up in this place and do anything, without permission from them or a court order. I can't go pick things up. I can't access the property without a 48-hour notice, and even then they have the right to dispute my access to the property. I'm not going to grant anybody access to the property because that's going to potentially hurt me. So I don't know. Unless there's a lawyer, I don't know where to find one. I've tried. I feel like I don't have a choice but to move forward because I've done all the calling I could to try to find one.
Yeah, I mean, and by the way, I'm the special master, so they're not my lawyer, they're the county's lawyer.
I understand
But
they're represented where
they
I'm
are
not.
represented.
Yeah.
That's why I'm asking if
Yeah.
you
I would
were
like to be, but I can't find one. And I don't know how. You continue me for a year and I still can't find one. I'm in the same position I'm in.
I think you
So,
could find one.
I've made a lot of phone calls.
The only reason I say that is because I've just, we see them, there are those who come. I'm not in a position to recommend folks. That's not my job.
So I guess at the end of the day, we move forward, and if I need to appeal, I appeal.
All right. So in that case, what I'd like to ask you to do is to look at these documents, take your time, and let me know if you have any objection to them.
So as I'm looking at the photos, some things I could obviously see stand out, and then some things, there's nothing circled or highlighted in the sense of what the specific complaint is.
Yeah, so this is a junk case, so it's section 20-31A, and here's what it says. It shall be unlawful for the owner or tenant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter, except for junk stored in enclosed litter receptacles or completely enclosed buildings, meaning that junk, debris, rubbish, vegetative matter that's spread out on the property is a problem.
Correct.
If it's in enclosed garbage cans or inside the house, that's not a problem.
And these photos are the first I'm accessing to these, so I don't know if any of this has been picked up or not.
Right.
Unfortunately, when this first got brought to my attention, it was via the letter because I don't live there.
Right.
I did understand that stuff needed to be cleaned up. I didn't know what needed to be cleaned up.
Right.
So I didn't get a detailed, hey, this is there, da-da-da. So I don't have current photos. I don't have...
Ms. Wilkinson, are there photos from your inspection yesterday?
Not here.
Yes. Okay.
Is there?
Yes.
Which ones are from yesterday?
They're dated.
Oh, okay. Where's the date?
On the bottom right
Oh, okay, it's in the photo.
corner.
And what's today?
Today is the 17th.
17th. Okay, so these are from the 15th. Where that fridge came from. That's nice to see. Okay, so so what I've told them Go ahead and submit this. I mean, obviously, a photo's a photo. I can't,
Well, you
argue with
could.
it.
You could say it was doctored, that some alien came and took it and they're not here to answer. I mean, you could.
Yeah. So they're
Believe it or not, over the years that I've done this, there have
Um,
been 2 successful objections to the photos.
So I feel like that they look like they've come from the road, so I don't feel like she's gone from any weird angles or anything like that. So I don't dispute the photos. This crap don't mean nothing to me. I don't know what any of that legal mumbo jumbo is, so I can't contest that. From the sounds of the way things are moving forward, I'm gonna need excessive amount of time to evict, and then I can clean up myself.
I haven't even seen the photos. So
Yeah.
let's before we get to that, I'd like to see the photos. So just because I don't even know what's going on yet.
So my mother and her boyfriend live there. I own the property. They've been there rent-free for 8 years. But my mother's, yeah. She lives on Social Security. She's very limited income.
Thank you.
But
Well,
before
unfortunately, you know what they say: no good deed goes unpunished.
I say that on a
sir.
daily basis.
So let me just have a moment to look at these so I can wrap my mind around it. Without objection, exhibits A and B are evidence, but let me just look and see through what's going on. So, Ms. Wilkinson, from the county's perspective, can you tell me what I see the photos, but what, from your perspective, are the actual violations? I presume the fence, the random fence material?
Yeah, so there's a pile of lumber in the front, and in the back, you can see in the far distance, there's a trailer full of random junk and debris. It's white. I don't know if you can see that or not in the photo. And some tires. And that's what I can see from the street without getting access to the property. You can see there's a lot of other stuff back there, but I can't determine what it is, so I'm
Is
not
the fridge
including
still
that.
there?
No, the refrigerator has been removed.
Okay. Have you had contact with the tenants at all?
Yes, I have, and he's been very nice.
Okay.
Mhm.
What have they indicated that they're going to work with you, or?
He's indicated that he's going to clean up the front, which he has made some attempt to. Again, he has also denied me access, which I understand. So there's not much to say about the case. It's just very limited.
Okay. Let me look at this. Okay. So, this is the first time you haven't gone by the property or anything?
So when I first got the letter, I obviously went by, what the hell?
Sure, yeah.
Why am I hearing this through a letter versus apparently she made contact with them directly? They have yet to make real contact with me without me reaching out. I have a hard time getting a hold of them to know what's going on, which is why when I did make contact with code enforcement, I informed them to contact me, not them. That was limited as well. So I didn't know how to fix a problem that I didn't know was a problem. So this is, now it's been presented to me. My plan moving forward is basically leave here, go drive to the courthouse, file eviction papers, and then however long it's going to take to do that, and then you guys can have more homeless in Citrus County. It's not my problem at this point, mother or not. It's not going to affect me. So I'm going to need a minimum 6 months because I don't know how long eviction takes.
Evictions definitely don't take 6 months.
But I don't have a contract.
Yeah.
I don't have a contract. I don't have a set rent. I don't have all that.
Well, if that's the case, then you actually do have rights to go on the property, and you should consult a lawyer.
I need to see where this is going to go, but I want to evict, and then I'll get it cleaned up. But I need at least 6 months to. I've got a job. I've got my own kids. I got my own life. This is a secondary type thing.
So in an eviction, they have 5 days to respond. Yeah. So these are actually very quick when you do them.
I knew that there was a whole stay on a lot of stuff because of COVID, and they started lifting a lot of that.
Long gone. So that's you're exactly right. The moratorium is long gone. Yeah. Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the action of the property owners. Once they were advised of the violation, we would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, I'm running some math in my head. Because I don't think the cleanup is really a 30-day cleanup.
Well, I'm not
I
sure.
think-
And unfortunately, the pictures are vague. I don't know what's there. If I'm gonna go there and clean it up, I'm gonna bring roll-offs or whatever I need to bring in,
Yeah.
and I'm gonna need time to do that. There's gonna be a huge expense with that.
Well,
Like you
that's
said, no
right. That's
good
why,
deed goes
that's kind
unpunished.
of why I'm running it in my head. In my
Um,
experience, it's not a 30-day, but I will find that a violation has occurred on the property, grant 120 days to bring it into compliance. I think that it's going to go faster than you think on the eviction side, but longer than you think on the cleanup side. And
How many months is 100?
4. So
Can I get a little more? Can I get extend as
well,
far as I can?
Thought about that is as far as it goes. Like I said, I think the eviction's faster than you think. I think you have more rights than you think to go right now and fix it. But I think the cleanup is going to take longer. So 120 days. If it's not brought into compliance as ordered, what was your recommendation?
$150 per
Okay,
day.
150 a day.
Can I come and ask for extensions if necessary?
You can appeal.
Appeal, okay.
Yeah. All right. Good luck.
Thank you.
Next case on the agenda,
Do I get some dockets so I can use that as?
I will issue an order. I'll issue an order.
When would that be available? Because I'm gonna go to the courthouse now, so if I'm gonna use this as staple for eviction, I have to see documentation.
as soon as I can prepare them.
Yeah.
And he signs them, they will be mailed.
Yep.
Oh, you mail them?
Yes.
You don't need it to file, but yeah.
Okay.
Yep.
Lynx Golf Sugar LLC, case number 2024-00079, Code Officer Julie Wilkinson, page 20 of your agenda.
Good morning.
Good morning.
Ma'am, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, please?
Penny Parks.
Thank you.
Are you an agent or owner of Lynx Golf Sugar LLC?
I am.
Okay.
All right. Julie Wilkinson, Citrus County Code Compliance Officer, case number 24-00079. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 1 Douglas Street, Homosassa, Florida. Property owner Lynx Golf Sugar LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on January 17th, 2024, a corrective action inspection on March 4th, 2024, and photos for my final inspection conducted April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
So, ma'am, I'd like to ask you to take a look at these documents. Let me know if you have any objection to them being evidence, but also let me know if you're contesting that a violation is on the property.
Okay,
Are you contesting?
I'm not.
Okay. I mean, if that's the case, then how much time do you need to clean it up?
Do you want to hear the whole thing, or do you just want me to give you
It
that?
depends. I mean, you have a right to tell me whatever you want to tell me, so I was just gonna cut to the chase. But if you want to talk to me about it, I'm happy to listen.
So, we would, well, first off, Officer Wilkinson is nothing short of amazing.
Oh,
Okay?
wow.
She's been,
You don't hear that every day at a code enforcement hearing.
I hope your boss is here. I hope this is recorded. I hope someone else hears this.
We're on YouTube, so
She's
here you
been responsive, she's professional, she's helpful, she's ridden the golf course with me, she's ridden the golf course with other people, she's terrific. She's trying to help. So my husband and I bought the golf course a little less than 2 years ago.
Mhm.
This is a failing golf course. It's in the middle of a community called Sugar Mill Woods.
Okay.
And if you followed anything about real estate and about golf courses that are shut down within the middle of a golf course, it'll destroy the community. The people that we bought from had told us that had we not bought, they were going to shut down the golf course. This is a golf course that has been neglected for 15 years. There are a number of tree problems, there's a number of issues that have to be alleviated on the property. And we...
Is it open?
We have, Sugar Mill Woods was originally 3 9-holes, okay? One of the 9 holes has been shut down for at least, I've been told, at least 5 or 6 years. So prior to us purchasing it, it had already been shut down. My understanding, and working with Code Officer Julie, is there had been a number of complaints that have been given over the years, and that prior ownership would be doing just the minimum
Right.
required to, there's like you have to.
I mean,
keep
that's
the
pretty
grass.
common at golf courses, yeah.
So we're trying to make it better. We're trying to fix up the golf courses, but it's a Herculean effort. Okay, we are on our 8th golf course superintendent, and the gentleman that was responsible for cleaning this up quit on Monday. Okay, that was the 7th, so we're on the 8th. Okay, so again, I'm not trying to act like my dog ate my homework. Julie's been wonderful. She's, I have a list of the places that we needed to work on. We've made progress. She'll tell you we've made progress. It's a lot.
Yeah.
It's a lot. We have broken down, we have 30-year-old irrigation systems. Just let me give you another for instance. Saturday afternoon, get a phone call from the golf shop. Some woman has plowed into our property. She's rounding the corner and missed, like from here to Julie is, right, you saw it, is the fire hydrant. So she was that close to hitting a fire hydrant, plows into our property, and destroys a number of other trees that we're now going to have to contend with. So it's, we have those sorts of issues. We have neighbors and members who have told us that people come and dump their debris on our property. Julie has seen evidence of that because she and I have driven around together. When the pile is like neatly stacked and wrapped, we know that that's not something that had happened. It's something that somebody's put. We've had people that come and trespass on the shut down 9 course and then go and complain about them. We were, it was advised to us, well, you can put up a trespassing sign, and that's not being a good neighbor. We don't want to do that to the neighborhood. So respectfully, we know we need to clean it up. We've made progress. Julie will tell you we've made progress, and I apologize for, I've known her so well, and she's been so great. I just call you by your first name. I hope that's not disrespectful.
Well, I guess what I'm curious about is how much time you think you need to get rid of the code violations. Not to make it perfect, but to get rid of the code violations.
So 6 months would be great, and I'll tell you why I say that. So we thought we would be able to burn the debris, because we piled up the debris. We were told we could burn it.
At this point, given the length of time you're requesting, I need to see the photos. So if you
Oh,
can,
sure. Sure.
I thought again foolishly that I could cut to the chase, but every case has a story, so I want to hear it. This will help me understand to know where y'all are coming from.
We're a small
It's
business.
a lot of space, yeah.
We're a small business. We're
Yep.
trying, we employ 80 people in Citrus County,
How many?
80.
Wow.
So we're
At the
probably.
golf course?
Yes, we have 2 golf courses.
Oh, okay. So, Ms. Wilkinson, without objection, these are admitted into evidence. What, from your perspective, are the violations? Just the vegetative matter?
Just the vegetative matter, and it's a lot. And I agree, 6 months, it's going to take a while to get rid of, and they do have problems with the people who live adjacent to the golf course bringing their vegetative matter and dumping it. It's all true.
All right. Is there anyone from the public who wants to be heard?
Yes.
Yeah.
Hi, my name is Carol Bush.
Actually, ma'am, if you wouldn't mind, come on up to the microphone. We'll swear you in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
Carol Bush.
Thank you.
Thank you, ma'am.
I have gotten several complaints. I sit on the board of directors,
The board of directors of,
Cypress Village.
okay.
And I understand it's a commercial golf course. My phone's been ringing off the hook, starting on Wednesday, this previous Wednesday, about the fires. Again, on Saturday, that there was an active fire, and the fire department was called. When I got there, there was nobody there. And there were small flames. The fire captain said that it was a relight. Now, I know this isn't the issue before the court, but the issue is that there are multiple piles throughout the golf course. I also took some pictures. Can I submit them, please?
Actually, no. Only the parties are allowed to introduce evidence. Members of the public are not.
Well-
But I want to know what you have to say.
The fire department responded on Saturday at approximately 12:45 and used 1,000 gallons of water and fire foam. And Saturday was a breezy day. Our homeowners are very concerned about this because the fire was not monitored at all. There was nobody from the golf course there.
I want to connect the dots. Are you saying that the debris is being lit on fire?
I don't know who's lighting the debris on fire, but that's what these pictures will show. I can also tell you that they used quite a bit of water, and the fire captain said that it looked like a reignite. And he also, I also called the forestry department, who did not issue a burn permit and said that they would need an air containment incinerator and in order to burn. So they did inspect the site and said that they didn't grant the permit, yet the piles were ignited anyway. So these are pretty big piles, and we have people that live all around this golf course. So I'm just here to voice how they feel about it. These people are also elderly, and some of them have breathing issues. And nobody wants to go into their backyard and look at dumped piles. And this is, they've noticed these for at least the last 8 months, these piles getting bigger and bigger. So that's all I have.
All right, thank you. Ms. Wilkinson, when did your case begin here?
In January.
In January?
Yes, sir.
So, ma'am, I guess you have a right to respond if you want.
So initially, we were told that we would be able to obtain, that number one, we would not need a burn permit. We would just need to simply notify the forestry department that we plan to do a burn, because it's incredibly cost prohibitive to move the amount of debris that needs to be moved. It's just cost prohibitive because it's that vast. So we made 2 attempts to call the forestry department and were told that we were not able to do so. On the 3rd attempt, we were told that we were going to be able to do that, but they needed to come out and look. They came out and looked and said that we could not obtain, that we would not be allowed to burn because the piles were too close to homes, so we would not be able to do that. So at which point we hired someone to come and hired someone to come and to take away a chunk of the piles. And I think that Julie will attest to the fact that they are lower than what we had done was, as we were taking debris off the course, we were piling it in one place because initially we were told we were going to be able to do a burn. So that's what we had done. And so then afterwards, we were told, when we found out we were not able to, we tried to take away a big chunk of it, which I think she will attest to, that's what happened. Somewhere in that process, something started to smolder, and there was a fire, which we were told had been contained. And yes, there were people, and there were people from the golf course that were around when that occurred.
Okay. I mean, I guess what I'm trying to understand is why it would take 6 months. I mean, I'm happy to listen. I don't understand why 6 months. That's a long time.
Yeah, there is, I've given you few photos in an effort to save paper, but there is a massive amount of tree debris piled in different piles in different locations all over both the abandoned golf course and the two that are currently running.
Well, look, I mean, whether the burns are permitted or not, I can't really do anything about that. But it's got to go, you know. So what is your plan for getting rid of it exactly?
So our plan is to work with our current staff. We can't afford to hire. Initially, when we bought the courses, we came in and hired a bunch of folks to do that. It's so much that we spent hundreds of thousands of dollars, and we can't, we're a small business, we can't afford to do that, to continue to bring in outside people.
I just want to know your plan. I know what you can't do, but what is
So
your
our
plan?
plan is to utilize our staff to do that, and that they will continue, through the course of trying to do other things, they will continue to get the piles, cut them up, and get rid of them.
Cut them up and then dispose of it how?
So like turn them into mulch, or turn them into, put them into places that are not a nuisance.
How big is this
site.
property?
Oy,
Or do you know, ma'am? I mean, what's the acreage?
So all of our acreage in total, the two golf courses and the sports complex are 465 acres.
Okay, all right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative costs to begin after the day you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
I don't like to do this, but because it's uncontested between the county and the respondent, I'll grant 6 months to take care of this, and that's really only based on the acreage involved. I mean, it sounds like it's such a big property that it's really not going to end up being a public nuisance. The issue is these burns. There's neighbors there that are having problems. So at any rate, if it's not brought into compliance as ordered, I'm going to go up a little bit on that, 150 a day, just to ensure compliance, and that's it. So good luck. You've got 6 months.
Thank you.
Thank you.
Next case on the day's agenda, Arcadio Morales Jr., case number 2023-01371, Code Officer Cody McGuire, page 24 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
He's already sworn in.
Yep, I remember that. Yeah, you forgot this time.
All right, Cody McGuire, Citrus County Code Compliance Officer. Case number 2023-01371, Land Use Districts, 2402 Rural Residential District. Address is 10555 North Brooks Terrace, Denellen, Florida. Property owner is Arcadio Morales Jr. Good service posting the property and posting the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during initial inspection on December 28th, photos taken during a corrective action inspection on March 4th, a subsequent inspection on March 25th, and photos of my final inspection on April 16th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property in a pre-hearing order.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any legal objection to them being evidence here.
Thanks. Just the last 6 pages are not up to date. They're screenshots of what used to be on the internet about 30 days ago, but like I said, 30 days ago.
Was on, all right, I'll take a look
Yeah,
at
you'll
it.
see it. That's it. Just the last 6 pictures. They're just not to date. As of 30 days ago, that's not been existent.
Gotcha, all right.
Oh, wait. I'm going to give you these as well as evidence of what I just stated.
I will get to your evidence. I
Oh,
just
okay.
have to see theirs first.
That's
And
fine. Whenever
The
you're ready.
reason, and by the way, the reason is that I don't even know what this case is about until I see what they're talking about. And
makes
then you'll
sense.
have an opportunity to do whatever you want.
Okay.
All right. Go ahead, Mr. McGuire.
Oh, sorry about that. Oh, this is the notice you put on the. Oh, yeah.
And is there going to be anyone from the public who wants to speak on this case? All right, I see no response. Oh, okay. You will. All right,
There's
thank you.
Everybody.
I'll make sure to bring you up. Not yet, yeah.
There would have been more, but they were kind of giving me the runaround about this hearing happening or not. Since I complied 30 days ago and, you know, cleared everything up, they kept saying that we don't have any proof of it, even though I thought this was. And yeah, run around until today. I just heard yesterday that the hearing was actually happening today. So thank you guys for actually coming last minute, everyone who showed up.
All right, so I'm going to reserve ruling on the last 6 pages of Exhibit A for now.
Okay.
I'll admit the rest without objection, but we'll get into that. And just give me a minute before you start. Let me just look and see what's going on. So there's a bunch of photos here that aren't dated. Pages 10 through 13. They appear to be photos taken from a vehicle, but they're not dated.
They're from environmental health.
They're from environmental health.
Yes, sir.
So you didn't take those photos?
Those I did not, but I was present during that
You were-
inspection.
I see, okay. Do you know when those photos were taken?
Those photos were taken on March 4th.
Are you sure?
Yes, sir.
Okay.
Of what
And-
year?
2024.
Okay. All right, so now I'm looking at the other stuff. You guys know how I feel about animals. All right. I don't know. Do y'all really need to be chasing animals out of properties? And, okay, all right, well, we'll see. I think I understand what's going on. I'll allow you to present your case, and then I'll let Mr. Morales present.
Okay. On December 28th, 2023, I conducted an initial inspection and observed a U-Haul signage along with 2 trucks and a trailer for rent. After conducting more research, it was discovered that there was a Glampground advertisement with photos on the website of HipCamp. On March 4th, 2024, a corrective action inspection was conducted with Environmental Health, where we were greeted by a man who stated that the property owner was not home and that we had to leave the property immediately because we were trespassing. As we were in the process of leaving, he asked why we were there, in which we replied again that Courtney was with VH and I was with Code, and we were there to try and make contact with the property owner. We were then again asked to leave, in which we did. After my inspections, I came back to the office where I was informed that I was unable to go to the property alone, that the man who greeted us at the door was in fact the property owner, and he made severe threats to my partner in EH, demanding that we never step foot on his property again. On March 13th, 2024, the property owner stated to my director that he is renting campers out as Airbnb. On March 21st, 2024, the property owner called and stated that all advertising had been taken down. On March 25th, 2024, myself and Officer Wilkinson went out to the property. Went to the property to meet with the property owner to go over on how to abate the violations. He stated that he had been in contact with land development and getting a zone and PUD change. While we were there, he invited us on the property to show us that he had gotten rid of all the glamping materials and advertisement.
Did you say glamping?
Glamping.
Okay.
As of my final inspection on April 16th, 2024, his phone number still remained up at Hip Camp. Though the property has been brought into compliance, this case is being brought to special master hearing due to the history of complaints and numerous violations.
Okay, so I think I understand. What the county is saying is it's not asking me to find that the property is in violation today.
Correct.
It is going to ask me to find that it was in violation so that if it happens again, they're a repeat violator.
Correct.
Is that right? Correct. Do you understand what the county's doing?
Oh yeah, whenever you're ready, I'll speak.
Okay. I want the county to finish presenting its case so that you have an opportunity to respond or whatever. But Ms. Coutu, are you a witness here? Okay.
9.6 acres, rural residential, mobile homes allowed. I think Mr. Morales has actually spoken to everybody in my office about a zoning change. It's not enough acreage to get a campground. So a zoning change to a campground, it's
What
not-
acreage is necessary?
10.
10?
Yeah, they're short.
But it's not a campground.
Can you obtain, it's not something you can get a variance for?
But perhaps for the U-Haul sales, you can apply for some kind of commercial PUD, and as a component of that, mix in some camping sites. I think it's very unlikely, and I'm always honest with people about that. They have residential in all directions. It's not a heavily traveled or heavily improved
You're saying
road.
it would be a spot zoning thing?
I think it
and-
would be very difficult to get approved. They can apply for some kind of unusual master plan PUD, but not a campground itself. The RVP zoning isn't going to make it here because of that acreage requirement.
Okay.
But there are some, maybe, but I just think it's very unlikely.
Okay. Is there anyone else from the county who wishes to testify? I mean, Ms. Wilkinson, Environmental Health. Is there anyone else who wants to testify? This is your chance because do any of you have any health, safety, sanitary concerns? Okay. All right. So I think what I want to do is I want to turn to you, Mr. Morales, and what's going on?
Well, as you know, my name's Arcadio, and I stand before you today as the founder and owner of Happy Campers Rescue Ranch. I want to take a moment to share the heartfelt story behind our humble beginning and shed light on the misconceptions surrounding our operation. Happy Campers Rescue Ranch is not a campground, and it's not just a business. It's a labor of love that began with a simple desire to make a difference in our community. After spending a decade in the banking industry, I made the bold decision to leave my career behind and pursue a new path, one that would allow me to spend more time with my children and contribute positively to our surroundings. Our journey started with a passion for rescuing farm animals and providing them with a safe haven to thrive. Over the years, we've expanded our endeavors to include property management for various locations throughout Florida, as well as collaborating with U-Haul to dispatch units for pickup at nearby locations via the phone. This did lead me to end up with 3 trailers, which I did allow people to come to my property and pick up so I can get them off, but I don't make any extra money for having them on my property. And as I told Cody, as soon as he told me that wasn't allowed, I got rid of them. He gave me a reason to give the guy to come pick them up. These dispatch units for pickup, these ventures have allowed us to support our family while continuing our mission to make a positive impact. I think per statute 559.955.
I'm sorry, could you repeat that?
Yes, 559.955, I do not believe that code enforcement can enact or enforce any ordinances or regulations or policies against our company. However, recent challenges have still arisen regarding our operation, particularly concerning the use of property for short-term camping stays. It has come to our attention that there may be misconceptions regarding the nature of our business, particularly related to zoning and land use. I want to make it clear that Happy Campers Rescue Ranch has never operated as a traditional campground and has never been a public property. While we did used to offer a few parking spots for guests who wish to experience the beauty of nature on our property for up to 7 days, our primary focus has always been on providing a sanctuary for rescued animals and educating the community that comes to us. We were not aware that guests who support our mission are not allowed to pop up a tent for a few days out of the year on our property, and we can't find anything in the Citrus County Code that restricts this. Furthermore, I want to address any concerns about the utilizations of my personal RVs on our property. While we have allowed guests to stay in RVs for short durations, we strictly adhere to Citrus County Code regarding RV usage and on developed land, and we have not exceeded the 14-day rule. Our commitment to compliance has always been unwavering, and we have always taken great care to ensure that our operation aligns with local regulations. 2 years ago, I actually called Citrus County Code Compliance and spoke with Hope. I asked her if there was anything I needed to do to start offering camping spots on my property as part of my business in Citrus County. And she, along with others, stated that they cannot say yes or no because there is nothing in the code that allows for camping, and informed me that they work on a complaint basis. So 2 years later today, a new neighbor moved in, built her house, and submitted a land use complaint, which has put a halt to the short-term rental part of our business that hundreds of guests have enjoyed and left their feedback. In closing, I hope to convey to the Special Master that there is no code violation occurring at Happy Campers Rescue Ranch, and to clarify what is and what is not actually a violation. Our property has always been private, and the operations we have conducted are in line with our mission of serving our community through Happy Campers Rescue Ranch.
All right, thank you. Actually, I want to take a moment, just look up the statute, because I may not be familiar with it.
I actually have a copy of it here. I brought a few statutes that I feel would help my case, but I'll just give you the one that I mentioned for now.
It's more helpful if I bring it up on my phone. So
Okay,
you said
no problem.
559.955. All right, I got it.
Correct.
Let me take a look at this. I'm familiar with this law. I've never seen it applied this way, but I think it's an interesting argument.
It even talks about parking spaces, you know.
It does.
And this isn't something I've ever done like outside of a business. I've always had a business license. I renew you're supposed to have a short-term license to do Airbnbs in Florida. And I mean, as a property manager and host for several locations, I have to abide by a lot of rules.
Is it the county's position that the property has been used as a campground?
Yes.
Okay, and why is that?
There's been multiple sightings of tents and people on the property.
Okay. And I'm looking at section 2402 in the Land Development Code, and it says that you can have a campground, but it's a conditional use. And so I think what the county's saying is it hasn't been approved as a conditional use here. Is that right?
Yeah, I've
Maybe
tried.
I'm wrong. I thought
as they
it's-
mentioned, I tried to go there and ask everybody. They just told me no. They said it works on a complaint basis, and it is what it is. Everybody else is operating out of code.
My question is to the county. I'm curious. So it appears that it would be allowed as a conditional use.
Recreational vehicle parks is a separate section, and you also have to comply with that, and that's where the 10-acre minimum comes in.
Oh, so you're saying that even as a 2402.
Right, even if RUR mentions it there are several other sections of the code you also have to comply with, in this case, an RVP. Like I said, there could be a hybrid, not likely, but we can do a hybrid, but a straight RVP zoning would be required for a campground generally. I think are you looking at rec or RUR?
RUR.
Okay.
Yeah. And the reason I'm asking, what from the county's perspective specifically is the county going to ask me to find was a violation?
The fact that he was running a U-Haul business out of the property and a glamp site.
So you're saying there's two different aspects of this.
There was.
You're saying there was a U-Haul rental, okay.
Dispatch.
A what?
I was dispatching U-Hauls from my property, but they weren't actually coming out of my property up until maybe close to a month ago, where I ended up with 3 trailers.
Okay.
Yeah.
And glamping. So, and by what you mean by glamping, I'm familiar with the vernacular, right? But what do you mean by that? That people could pay to camp there?
Correct.
Whether by tent or otherwise?
Correct.
Okay, so I just need it laid out for me like I'm a kindergartner.
Okay.
What, is that a violation of 2402? Are both of those violations of 2402?
Yeah, glamping is another term, but it's a campground. So he's testified that people have been staying there overnight in tents and in RVs. That is a campground.
Can we look up the Florida statute definition of campground?
That actually doesn't apply, but so,
Okay.
yeah.
It's that violation of selling or operating a commercial business where it's visible. That wouldn't qualify for home occupation in RUR. So in RUR, you'll see that you don't see office or dispatch or whatever he wants to call it.
So, yeah, and so that's, I just want to make sure I'm on the mic. So in RUR, let's see.
It's extremely limited. It's residential and some agricultural uses.
I'm actually surprised by how limited it is.
Yeah. It's our rural areas where we want to keep farming and houses, and that's it.
I don't see anything in RUR for really almost, it's pretty strict.
Yes.
Okay. All right, so what you're saying is under the RUR zoning, neither the U-Haul business is a permitted use, nor one approved by a conditional use, and either is the glamping at a minimum due to the size.
Correct.
And even if the size was enough, they'd still have to have a conditional
Still
use
have to have
approved
at a
by
minimum,
the county.
Yes.
And as we sit here today, there is no violation on the property.
That's what he's observed, yes.
Okay.
Can we refer back to the home-based business? Because they're talking about the U-Hauls now too. And I mean, yeah, the camping thing I thought about. That's why I called and asked, hey, is this okay? And I was kind of given the yellow light. But this is straight up a home-based business. I've even hired someone to work the dispatch as well. And I only ended up with 3 trailers a month ago, which she told me I can't rent from the house, so that's fine. But yeah, if we could just refer back to that, I feel like this is the key.
It's just going to take me a moment to absorb all of this.
Yeah, in your land development code, there's a special section about home occupations, and it says there has to be no visible evidence of the occupation. The presence of that U-Haul sign on the road wipes that out immediately.
Yeah, that's not there anymore. As soon as he told me it's not allowed to be, I took it off.
They're not really contesting that. What they're saying is that it was there. And so that's enough that a violation occurred.
Yeah, I knew it. When that guy asked me about putting up the sign, I thought about it. I should have listened to my gut. I was like, this is kind of weird. Just because I got 3 trailers here, you want me to put a sign? And I did it, and that's what happened.
But I think your argument is worth looking into, so I'm just going to look through the statute real quick.
Yeah, I also tried to find a lawyer like the other guy, too, and ran through the same exact issues.
Oh, they're out here. They appear.
When I heard you say that, I mean, I have more hope now.
I can't name names, but
I wish you could, man.
all our hearings are on YouTube, so you just journey back. And
Yep, I know they're hours long. I got to
they
really
are
just
hours
go
long.
through them.
Welcome to the show.
Mhm.
Local laws.
I fell asleep to a few of them.
So the application of the section does not supersede local laws, ordinances, or regulations related to transient public lodging. But that's not really the issue here. Okay.
So can I ask a question here to code enforcement?
No, hold on, let
okay.
me, if you don't mind, let me.
Oh, yeah,
read this
sorry.
Statute. I want to really understand your argument.
Okay.
And do you reside on the property?
I do, yes.
Okay.
I'm always there. I don't ever.
Where do you reside on the property?
In the center, actually. I have a drone shot I took this morning. I also have a drone video that I did walk around. It's on this SD card because I know you
Do you
can't
have any
give a-
reason to disbelieve that?
What's that?
Do you have any reason to disbelieve that he lives on the property?
No.
Okay, all right. It's uncontested.
Okay.
So that satisfies subsection 3A. Parking related to the building complies with local zoning requirements. As viewed from the street, so Ms. Katu, is this what you were talking about, subsection 3C of this statute? Where it says, as viewed from the street, the use of the residential property is consistent with the uses of the residential areas that surround the property?
I haven't even seen the statute you guys are referring to. I was referring to the
Okay.
land development code.
Is this the first time the county's aware that they're making this argument under this statute?
I don't recall it.
Okay.
Is this the Right to Farm Act that we're doing?
I brought it up to JC about a month ago.
Home-based business, okay.
Yeah, this is a relatively recent statute.
Right, we have our
designed-
home occupations in the land development code. I'm not familiar with that statute
All right,
very
so
well.
let me read sub C. As viewed from the street, the use of the residential property is consistent with the uses of the residential areas. External modifications to a residential dwelling to accommodate a home-based business must conform. The home-based business may not conduct retail transactions at a structure other than the resident. However, incidental business uses and activities may be conducted. The activities of the home-based business are secondary to the property's use as a residential dwelling. The business activities comply with any relevant with respect to signage and equipment or processes that create variation. A home-based business that operates from a residential property may operate in an area zoned for residential use, may not be prohibited, restricted, regulated, or licensed in a manner that is different from other businesses in a local government's jurisdiction.
I just want to mention something as for subsection C, as viewed from the street. I've always made sure that absolutely none of my neighbors could see anybody from the street out of respect. The reason, or the way I was discovered was actually that new neighbor that I mentioned that moved in. She came to my property back in December, like late December, and she pretended to be someone else. She didn't tell me she was the neighbor. She told me that her sister booked a site or a camper at my property, and I wasn't booking campers because I had exceeded the 14 days. And I told her maybe it was a tent site, and I invited her back to the property to check it out. And again, didn't listen to my gut, and I walked her around. I showed her everything and told her about her operation, and I welcomed her and her family if she wanted to book with us. And she, 2 weeks later, told the, code enforcement what she told him. Prior to that, you couldn't see anything. You don't know what I was doing at my house.
You mentioned other statutes that you had. I just want you to put everything on the record that you
Yeah.
think might apply.
Well, the other one you said didn't. It was the definition of campground and lodging park.
Oh,
and
yeah,
all
the
that.
Florida statute. The only reason is that it's a definition, but I actually put on the record what you got.
Okay, I'll just pull this out here, and then the other thing was.
And actually, I do need to know that definition because in section, let's see, in section 1500, it says 1500F, definitions herein are based on the meaning given to them according to the following order. Number 1, comprehensive plan. Number 2, Florida statutes. So if there's a comp plan definition, that controls. If there's something in the LDC, that'll control. But in the absence of that, a Florida statute definition would be helpful. So what is this?
I'm really sorry to make you look it up, but I printed out the wrong one. It states campground means 7 or more sites, and it's some other things that you'll find yourself.
Do you have a statute number or anything?
It was close to
don't-
509-242,
Okay.
but this one talks about hotel, motel, vacation rental. I printed out the wrong. So I should have printed pages 1 through 3, and I printed 2 and 3.
All right, let me look at this. I got it.
Okay. Yeah, you'll just have to find the campground one,
Yep.
because it's obviously not motel,
I think
hotel.
I do have it. Let me see.
Oh, you can? 3310. Says it.
I think I actually
So
found it.
in 509.502, subsection 3, there is a definition of campground. But what it says here is means any real property which is a part of a membership camping plan. This term does not include a mobile home, lodging, or recreational vehicle park or recreational camp as defined in Chapter 513, so long as no membership camping plan is offered for sale, sold, or otherwise promoted. So is this the definition you were talking about?
Close. There's a recreational camp here. I've got it. Means 1 or more buildings or structures, tents, trailers, or vehicles, or any portion thereof, together with the land appertaining therefore, established, operated, or used as living quarters for 5 or more resident members of the public.
Well, but this says campground, so that's why
Okay.
I thought that would be the relevant definition. And
Yeah,
that-
I didn't print that one, but I got
Okay,
the
but it doesn't
recreational camp.
apply because that has to do with membership camping.
Okay.
So I think that what that requires then is I have to use my common sense to, or a dictionary to define it. Has the county considered whether this statute applies? Why or why not?
What I was told is that I forgot who in the office said this. It was a female said that their rules overrule the Florida statutes, just like state laws overrule what other.
Well,
you
they
know what I mean?
might if a certain subsection of the statute applies.
Yeah,
So
if they mention it in there and define
at the very
campground.
end, it says there's an exception where local rules would control, but I don't think that applies here. And so this is a matter of first impression for these hearings. It's never been raised as a defense. But I don't see why it wouldn't apply. So I need to, what I'd like to do is hear from the public, actually. People have come, I think they should be heard. Who wants to address this case from the public? I know there's at least one. Sir?
Well, I just want to.
If you don't mind.
I don't know too much.
That's okay.
You gotta swear in.
That's okay.
Yes, ma'am. Yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
And your name, please.
Juan Leon.
Thank
Juanleon. Leon. Yes, ma'am. Yeah, I just want to say like something over here, like from my own perspective, okay? Like I think like there's an overreaction of the neighbors. You know what I mean? Like because like well, I want to say like that's a discrimination because like it truly, his property is a very, very, how to call, a very rough country. You know what I mean? So in contrast, of course, with the neighbors. The neighbors is, you know what I mean? Even, I believe that there's like $1 million probably property next to him. I mean, from my own judgment, all right? But I've been knowing this young man over here for a while. He's a very hard worker. He used to be a banker, you know what I mean? Like midterm, also like a mid manager, you know what I mean, department. He very smart. And he decided to, you know, he make like his own business. And so like, but it's not like, since like that's a neighborhood, now it's growing, there's a cheap land over there. See, wealthy people want to move then, you know, around here, you know, maybe there's some contrast, you know what I mean? And from my own perspective, I think like there's some discrimination over here. Sorry about that. That's what I want to say, okay?
His fact comes from a video that I showed him when I went to speak to a neighbor.
And actually, so sorry, I got distracted, but I do. Did you have other things to say? We're not.
Well, no.
No, I want you to. The public has an opportunity to speak, and you know, whatever else you want to say, you can.
Yeah, that's what I just wanted to say.
Okay.
Yeah, thank you.
All right. Sure. Is there anyone else from the public who wants to be heard, ma'am?
What I was, can I speak?
Well, not quite yet.
No problem.
First off, I do want to apologize for the outburst earlier.
I'll survive.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And your name, please?
Carla Fuster.
Thank you.
Thank you.
I just want to let you know, this business that we've been running, I've been loving watching him grow it. It's definitely a part of his life. He's trying to do it for his kids, not only for his kids, for my kids too. So just seeing, you know, somebody trying to stop it, it's devastating. And not only is it hurting, it's hurting us. That's it.
Thank you. Is there anyone else from the public, sir?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your name, please?
John Cunningham.
Thank you.
So I've known Arcadio for about 8 years now. I'm a real estate agent. I don't know the rules as well as you guys know the rules. So I'm just gonna basically talk off, you know, speak from experience. My girlfriend and I, I'm from New York, so camping and all that stuff, I was like, that's crazy. I'm not gonna do it, but I did it. And I went to his campground, and it's secluded. I've gotten a chance to mingle with the animals, the goats and all that stuff. And I see the good that he's doing for the community. I see the good that he's doing for his kids. Now, I know the facts are the facts, but just knowing Arcadio, I know how he operates. I was his real estate agent, so everything is cross your T's, dot your I's. He's that type of guy. So for whatever it's worth, I know he's doing well for the community, and you know, I hope that means something to you all.
All right. Thank you, sir.
You got it.
Is there anyone else from the public who wants to be heard on this? Now would be your chance. Unless I continue the hearing for some reason.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name?
Anthony Green.
Thank you.
I'll make this short and simple. I know the other people who spoke very well. I just want to say, from what I've seen, from what I've heard about his business, I know coming through the street, other than the one U-Haul sign, you wouldn't be able to tell first thing it was there. From what I've seen, everything he's done is very safe, very conscious, and that I don't think is an issue or ever will be an issue.
Okay, thank you, sir.
Absolutely.
Is there anyone else from the public who wants to be heard? Ma'am?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Emily Green.
Thank you.
I have known Arcadio for not a long period of time, but long enough to know him as a person and as a business owner. his property is very private. Can't see anything from the road aside from the U-Haul, which once he found out, he took care of that issue. The people who have come on the property he's very communicative with them, and he knows he's never had his campers plugged in for more than 14 days out of a year. He tries to abide by the law and statutes that he is aware of. I don't know who memorizes that entire thing. I wouldn't know.
Who memorizes this?
Yeah.
Yeah.
I couldn't.
Well,
Look up what I can.
When he's aware, he definitely tries his hardest to bring everything to code. And me and my husband have worked very hard trying to help him on his property get everything the way that they needed. And he was very communicative with them, calling them all the time, often with phone calls never returned. And he asked all the questions that I feel would be necessary. And he runs his business on a very respectable standard, in my opinion. Like, he's definitely very communicative with them on what he is and is not allowed to do on his property. And the kids that come out there, they love the animals. It gives them a lot of educational experience, and then they also get the safety of not being like in the woods. Like, I don't know who would want to go camping in the Ocala National Forest and get eaten by a bear. But on his property, there's not those issues aside
You'd be surprised.
from yeah,
Yeah.
aside from like a rhea and some goats. Like, the kids enjoy it. They're able to go into the backyard and play on the swing set and pet the animals, and I don't see anything wrong with what he's doing besides offering a very good family experience in a safe environment.
Okay. Anything else?
No.
Thank you.
Thank you.
Is there anyone else from the public who wishes to be heard on this case? I don't hear any others. I'm going to ask the county. I guess one question I have is, and ma'am, you're from EH?
Yes.
I'd like, would you mind if I asked you some questions? Or do I have to issue a subpoena?
No.
Okay. You said you don't have any, sorry, I'll let you be sworn in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And state your name, please.
Courtney Carmichael.
I think this has been overwhelming support for the property, and the county doesn't contest that it's in violation today. But when I asked you earlier if there were any concerns, you said not anymore. What would have been your concerns? I have to consider if there's health, safety, sanitary concerns. What would have been your concerns?
When we originally went out, we were called out.
Thank you.
Sure. When we originally called out, I came out to the property. I took along with Cody, and we drove from the road to the
Did you have a
front door.
complaint, or?
We did have a complaint of a possible illegal RV park, but our jurisdiction, since it became very threatening, as myself, I was told I wasn't allowed to come back out to the property again, and I was made very aware of how quickly I could have been shot in the head and killed
Why?
for coming onto the property. I did make
Did you
sure
come out? You went on the property without permission, or?
we went from the driveway from the road to the front door.
Long driveway with a private property sign, and I want to apologize for that miscommunication.
I did go back out to the
Yeah,
road.
'cause I didn't
I mean, that's one way of.
I know, I didn't
that's
say
one-
that. I said
calling
you-
it a
you-
miscommunication.
At
That's,
your with your type of job, if you do the work like you're doing it, they could easily happen.
Oh,
I was
of
just
course.
warning you because you
Well,
guys tried to access it from the
Sir,
side
let me
first.
just hear what she has to say.
I just
So-
had to
Sorry.
apologize. I didn't know she felt like that. That's not
Well,
good.
so I want to take it a little bit at a time. So you.
We
you,
arrived.
You went, and were you both together?
Yes.
You went onto the driveway. It is, I've seen the photos. It's quite a. It's not
It
right
is.
on the road.
It is, but because I did my research before I went out there, I knew there were animals on the property, and also with environmental health, we worry about rabies, bites, all that great stuff. So I was a little worried about animals. After we were asked to leave the property, and he said that there was trespassing signs still posted, I went out to the road, took photo of both entrances, and there was no trespassing sign visible. It was laying on the ground, flush with the ground, next to a
Okay.
cone.
All right.
So had I seen that sign, I would have done more of a honk and had him come out and speak to me.
Okay.
He never did identify himself as the owner of the property. He kept telling me he was not the property owner, and I needed to wait for the property owner to come back.
Well, I guess, but what I'm really asking about is the health concerns, and I get that. I mean, I get your perspective. Honestly, I get his perspective. It can be dangerous to do what you do sometimes.
Yes,
you
it
know?
can.
But what are the health, safety, sanitary concerns?
The questions we had were, in fact, because the Department of Health and Environmental Health jurisdiction over mobile home parks of certain sizes under, I think it's 600 lots, I believe. And also RV parks, limited use well, which means people are using the water that he provides from his property, and that requires sampling for safety. And then the restrooms, and what we were told, and just not getting questions answered, all I knew of is that they were using the restroom in buckets, and that there were some showers hooked up to the water hoses, and those then became the main focus, is providing water to the public without it being safe. And
I'm familiar with those concerns.
Yeah,
Okay, so
that
that's what
was-
y'all were
Mhm.
interested in, and the proper disposal of any of that.
Mhm.
Okay, all right, that makes sense to me. Is there anything else you want to say? All right, thanks. Have you guys had a chance to look at this statute?
Which statute?
559.955.
We read it along with you.
All right, can you guess what I'm gonna do? What I'd like to do?
I can't guess what you're going to do.
Good, then I'm not predictable. But I think you probably can. So my concern here is, because I'm so new to this statute, I don't want to make a wrong decision one way or the other. I need to understand how it might apply or not apply. So regrettably, I know the county doesn't enjoy this. I'm going to continue the hearing to next month and not issue a ruling at this time. And what I'm going to do is issue a formal, what I call briefing, or it's not going to be long. I can tell you pretty much what it's going to say right now. I want to understand how this statute applies or does not apply to the operation of the U-Haul business as well as the glamping. Because that's what the county said were the two violations. And I think this is a unique argument. So that's what it's going to say. And I'll ask for the briefs to be no later than 1 week before the next hearing. And going to continue it till then. May 15th? Okay. Any questions? I'll issue it in writing so you'll get
I
it.
do have one question. So, this is obviously hurting our pockets a lot. 30 days of no income is a lot. So, can we, like in front of them, I'm asking, can we continue until next month until we figure out that this is actually not a violation?
That's between y'all. What I can say is that as the special master, I'm not saying whether it is or is not a violation at this point. They're telling you right now that you're in compliance. So, look, I'd really like to give you, one way or the other, a ruling. If I find that here's a choice. Here's something you could do, is you could concede that there was a violation. There's no fine involved with that. It's just a finding that there was a violation, but you concede it. And that means if another violation occurs again, then it's your repeat violator, and you still end up, if you do it again, you end up having fines.
Correct. I don't want to break any laws or anything.
Right. So I don't know if long run, it's up to you, but that's a way that maybe you can find a way of getting income doing something that the county approves. I don't know. You still have to run it by them.
Yeah, no, it's risky continuing for right now, but it's a whole nother 30 days and I'm going to have to wait. That's why I asked.
If
it's
I
worth
had
it,
known
it'll
what
be
your
worth
argument
it.
was going to be, I might have been able to think about it ahead of time, but I don't have the proper information I need to make a decision.
No, that's fair. Yeah, it's fine.
So it's continued. All right. Thank you.
Thank you.
Thank you.
Next case on today's agenda, KM and KM Martin Trust, case number 2024-135, Code Officer Brandon Norman, page 21 of your agenda.
Just
And
notice-
case,
notice that
we're-
page number.
It's 21 and 22. There's also case number 2024-153.
And these are both the same properties, so we're.
Correct.
Okay, all right. Good morning, or
Good morning, sir.
afternoon, sorry.
Good afternoon, Brendan Norman, Citrus County Code Compliance Officer. This is for case 2024-00135, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and for case number 2024-00153, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. This is for address 11593 East Salmon Drive in Floral City, Florida. Property owner listed as K.M. Martin and K.M. Martin Trust.
Brandon, I'm sorry, I
Yeah,
didn't
no.
swear her in.
Oh, I
Yeah, no, I
apologize.
was waiting.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Paige Martin.
Thank you.
Sorry.
Not your fault.
I have good service via posting at the property and looking into a government building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on January 25th, 2024, my corrective action inspection done March 14th, 2024, and my final inspection done yesterday, April 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed along with a photo of the posted notice of hearing at the property.
Okay, ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them.
Okay.
Ma'am, are you contesting that either of these is a violation?
No, sir.
Okay.
I'm not contesting that there is a violation. Apologies.
On either of the cases? So you've got an overgrown grass case as well as a junk case?
Yes, sir.
Okay, so there's a violation in both.
Yes, I sort of thought they were one thing. That's the confusion you're seeing on my face.
I hear you. Well, we're presenting it at once to save
Sure.
time. How much time do you need to bring the property into compliance?
Well, Mr. Norman has been very understanding that last year I had health issues which contributed to the overgrowth and also some significant family issues earlier this year, which forestalled me from being able to actually start addressing it, which is why we're here today.
I understand.
So, as I said, he's been understanding.
Thank you.
I have made progress. We've discussed it. And if I can have the additional 60 days, that appears to be somewhat normal.
Okay,
I
let me
believe
look.
I can come into compliance.
Exhibits A and B are admitted into evidence in each case. The violation in each case has been conceded. I'm looking through the photos. Looks like it'll take a little work. So you have some circumstances where you'd require more than 30 days to get this done? Like 60 days you think is something you need?
Yes, I would like to continue to talk with him about what's okay. I keep the yard a little brushier than many people because that increases. I'm a wildlife biologist by training.
Oh.
So I keep the edges. I keep the edges brushy. I've got wrens and things that come. I've got snakes. Not poisonous snakes, as the neighbors.
I
have
mean, 18
complained.
inches gives you a lot of leeway.
Huh? What's that?
18 inches gives you
Oh,
a
no,
lot of
it's-
leeway.
I
It's-
think that has the issue been more of the stuff along the side, or
So-
well, there were weeds from last year.
Yeah.
As I said, I had a health condition last year.
Yeah. So originally it was the front of the, it was mainly the front right side of the property that was severely
Oh.
overgrown.
Okay.
But I mean, even since then, I can contest, or I can agree with her that she has been working towards it. She's made a lot of progress. And then once we established communication, she's been extremely communicative and letting me know what the progress and what she plans on
What's the
doing.
county's recommendation on these cases?
For both cases, the Citrus County Code Compliance Division would respectfully request that the special master assess a fine of $50 per case, along with administrative costs, to begin after the dates that you deem sufficient to abate these violations. It was selected based on the actions of the property owners once they're advised of the violation, and it's appropriate given the severity of the violations and their actions relative to these violations. We'd also ask that you find that it's the responsibility to contact the Code Compliance Division once the violations have been abated in order to come into compliance, or in order to allow for reinspection. And at my inspection yesterday, we did talk briefly about kind of what is expected for the lawn ordinance. Essentially, if it blooms, I typically don't, like dandelions, yeah, that's a weed, we all know that, but if it blooms, typically we don't.
Well, I don't know, definition of a weed is an unwanted,
We're not doing that brief
No,
again.
We're not,
we don't have to do the brief. I know all about weeds
I
now.
asked specifically about some very,
Yeah.
it is a native plant that grows very tall.
Of course.
And
Yeah.
is blooming, so
Listen.
that's where that conversation.
Yeah.
That's not a weed, if you
No,
want it, okay?
It blooms and it's
Okay,
not
great.
it's not a
Okay.
nuisance, so.
Okay, well then, I just don't think, I mean, I get it. I get it on the junk. It just doesn't seem like it'll take that long to get the grass taken care of. I
What,
mean,
is it the grass or is it the, because we talked about, I have the brushy fence line.
Yeah,
So
so,
weed
I guess I
whacker.
need more specifics.
so it would be the brush along the fence, it just needs to be under the 18 inches.
All the brush on the fence
yeah,
except for whatever
yeah,
trees.
Exactly. Yeah.
Okay. Okay. I am limited to pretty much Saturdays and every other Monday, so that's why I say it's.
Okay.
I'm not,
On each case, I'm gonna grant 60 days, and if it's not brought into compliance, as ordered, $50 a day.
okay, thank you, sir.
All right.
Thank you.
I'm gonna adjourn and go to just for 5 minutes. All right. 12:22. It's 12:27, we're back in session. Sorry about that, I just had a coughing fit, so. Ready for the next case?
Next case, Ray and Judy Calhoun, case number 2024-150, Code Officer Julie Wilkinson, page 6 of your agenda.
She knows she's.
Okay, I got you.
I got a cough drop in my desk if you need one.
I think I'm okay for another half hour, so let's
Oh,
see
okay,
what we
let's
can.
speed it up then. Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400150, accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6405 South Lima Drive, Homosassa, Florida. Property owner is Ray and Judy Calhoun. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 1st, 2024. Corrective action inspection on March 5th, 2024. And photos of my final inspection conducted on April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wants to be heard on this? And let the record reflect, I don't see anyone from the public present, so I'll no longer ask that question.
Sorry.
Without objection, what's been proposed as exhibits A and B are evidence.
On February 1st, 2024, I conducted an initial inspection and observed auto parts, household items, furniture, a large pile of tree debris, loose trash, miscellaneous junk, and debris on the property. On February 19th, 2024, a notice of violation was issued for accumulation of junk and debris, which is a violation of the Citrus County Code of Ordinances. On March 5th, 2024, I conducted a corrective action inspection and observed that the property remained in violation. As of my final inspection on April 16th, 2024, the property remains in violation. I have had contact with the occupants of the property who have been pleasant during this process.
What's your recommendation?
$100 a day.
Okay, I'll grant 60 days and $100 a day.
Thank you.
Thanks.
Next case, Bradley and Kristen Keene, Revocable Living Trust, case number 2024-54, Code Officer Cody McGuire, page 16 of your agenda. Land Development Director Joanna Cantu, expert on the case.
What's that? We're doing them separate?
Are they
Two
two
different
different addresses? Yes.
And this is 5-4?
Yes.
Yes.
Thank you. Cody McGuire, Citrus County Code Compliance Officer, case number 2454. A violation of Citrus County Land Development Code, Section 4002, site development without a development order. Address is 14764 West Black Creek Court, Christian River, Florida. Property owner is Bradley E. and Kristen R. Keene, Recoverable Trust. Good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on January 9th, subsequent inspection on January 10th, corrective action inspection March 12th, 2024, and a pre-hearing inspection on April 16th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, a copy of the notice of hearing posted on the property, and a posting affidavit.
Okay, without objection, what's been proposed as the exhibits are now evidence. Thank you. Yeah, I can see some work being done here.
Continue?
Yes.
Okay. I conducted my initial inspection on January 9th and observed that the property had trees removed and loads of fill that were brought in and spread. On January 10th, January 10th, 2024, me and my director went back out to the property and actually made contact with Mr. Keene. But while researching the property, I observed there have been no permits applied for or issued. I've had contact with the property owner who states that he plans on building in the near future, but the hurdles that he has gone through has slowed him down, involving DEP and environmental specialists. As of April 16, 2024, no permits have been applied for.
Ms. Katu, do you want to testify, or? Well, I mean, honestly, I don't know the answer to that. Do I?
Smiling and waving, but 0.31 acres CLR MH, there's no applications as of this morning.
Okay, thank you. What's the county's recommendation?
Due to the irreversible nature of the violation, the Citrus County Code Compliance Division respectfully requests that a special master assesses a one-time fine of $2,500.
Okay, I will do so.
Okay.
Thanks. And find the commensurate violation.
Okay.
Next case on the agenda, Bradley E. Keene and Kristen R. Keene and the Revocable Trust. Case number 2024-69, page 17 of your agenda, Joanna Katu, expert.
Code of McGuire, Citrus County Code Compliance Officer, case number 24069, a violation of the Citrus County Land Development Code, section 4002, site development without development order. Address is 14752 West Black Creek Court, Christopher, Florida. Property owner is Bradley E. and Kristen R. Keene Recoverable Trust. Good service via posting the notice of hearing on the property and posting of the Canto Government Building. Sorry.
Yeah, take your time. I've been there, yeah.
Thank you.
Yeah.
I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, a photo I took during my initial inspection on January 9th. Subsequent inspection on January 10th. Corrective action inspection on March 12th, 2024. And my final pre-hearing inspection photo on April 16th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the notice of hearing posted on the property with a posting affidavit.
Okay. They will be admitted as evidence.
Bless you.
Thank you. Go ahead.
Okay. I conducted my initial inspection on January 9th and observed that the property had a few loads of fill that were brought in and spread. Subsequent inspection on January 10th with my director, as we spoke to Mr. Keene, who stated he was basically getting ready to build, and he jumped the gun, in all honesty. And he said that he has stumbled across several additional hurdles that he was not aware of. And as of April 16, 2024, no permits have been applied for.
What is the county's recommendation?
$2,500.
Okay, I find that a violation has occurred and assess a fine of $2,500.
Thank you, sir.
Next case on the agenda, Gray Gaunt, case number 2024-00029, Code Officer Julie Wilkinson, page 11 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400029. Accumulation of junk debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 8190 West Miss Maggie Drive in Homestead, Florida. Property owner is Gray Gort. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during initial inspection on January 9th, 2024. Photos from a corrective action inspection on March 4th, 2024. And photos from my final inspection conducted on April 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, the exhibits are admitted as evidence. Thank you. What's the county's recommendation?
$100 a day.
100?
Yes, sir.
Okay. Let's see here. Certainly see the violation. Anything special you want me to know before issuing a ruling?
No, it's pretty
Okay.
straightforward.
Okay. I'm gonna say 30 days, $100 a day.
Thank you.
Thanks.
Next case, Melody Horlick Gardner, case number 2024-00230. Code Officer Alan Jonason, page 14 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00230, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4249 East Scott Lane, Dunellen, Florida. Property owner Horlick Gardner Melody. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 8 February 2024, photos from a compliance inspection on 11 March 2024, and photos from my final inspection conducted on 16 April 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
They're admitted in evidence. Thank you. Yep, I see what's happening here. Are these photos that you're showing me just the one lot? Or
Yes,
are they?
sir.
Okay.
Yes, sir. Yes, sir.
What's the county's recommendation?
$150 per day.
Now, this looks like, I don't know if, I mean, it's 30 days seems like that would be rough for this person. How big is the lot, do you know?
It's small, probably
Quarter acre?
Quarter acre, the most.
Oof. Has there been any improvement?
No.
No.
I've not had contact with anybody either.
Okay. I'll grant 60 days, if it's not brought into compliance as ordered. Did you say one?
150.
150.
Yes, sir.
All right.
Thank you.
Next case, Melody Horlick Gardner et al. Case number 2024-00229, Alan Jonason, page 15.
Alan Jonason, Citrus County Code Compliance Officer, case number 2024-00229, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 4253 East Scott Lane, Dunellen, Florida. Property owner Horlick Gardner Melody and Gardner Frank Michael. I have good service via posting the notice of hearing on the property and posting in the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 8 February 2024, photos from a compliance inspection on 11 March 2024, photos from my final inspection on 16 April 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
All right. The exhibits are admitted as evidence.
This is the property that's off the right of the one we just
Okay.
went through. Yes, sir.
And I think it's absolutely self-evident from the photos that there is a violation. What is the county's recommendation?
150.
Wow. This is gonna get bad during the summer. All right, 60 days, 150.
Thank you.
Thanks.
Last two cases on the agenda. Henry Dean Prather, case number 2023-01268. and 2023-01321, Code Officer Brandon Norman, pages 26 and 27 of your agenda.
I was promised some overgrown grass cases, and
It abated.
I got you.
I'm
We
sorry.
got you.
Okay.
Oh, no, this one didn't abate. Okay, here
No,
it is.
we have one already.
Yeah, we had like one or two. We
Yeah.
need.
This is
I
one.
really.
I decided to give you a break this month.
Okay.
I've only got like 5 cases at all, so.
No, Julie was the winner
Yeah,
this year.
Julie stepped it up though.
Yeah, I'll say.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01268, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case 2024-01321, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances.
Brandon?
Slow down.
No, well, the case number, you put 2024.
Oh, I apologize. 2023-01321, not 2024. The address is 9541 East Lazy Oak Drive, Floral City, Florida. Property owner listed as Henry Dean Prather. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A for case ending in 1268. The initial inspection was done on December 4th, 2024, so I have photos from that. And then Exhibit A for 1321, the initial inspection, my photos will show December 7th. All the other dates correlate for same inspections, though. The corrective action inspection photos from March 18th, 2024, and a final inspection done April 16th, 2024. Exhibit B for both will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Exhibits A and B are admitted into evidence in each case. Thanks. Let's look at the lawn photos first. This is, well,
There are some strange circumstances on this one, so. Well, I wouldn't say strange, but
It's
there's some
interesting. Huh.
different circumstances.
Well, what are those circumstances?
So I originally had, this came as an unsafe structure request. It was then passed off. There are some other cases for unsafe structures, and he's working on those. He also had 2 additional cases on the adjacent property for junk and overgrown lawn. Working with him, he's able to get that property cleaned up. We've got those 2 closed, and
Wow.
now we're focusing our attention on these.
Oh.
He is disabled. He's very friendly, very polite, and extremely communicative. I probably hear from him at least twice a week. He's doing his best with what he's got available. So I did give him an additional 30 days from the initial notice of violation corrective action because he requested it. And once we closed those other 2 cases, I decided to oblige and grant him that additional 30 days. Just because he has quite a few cases with us right now, trying to manage and bring them all into compliance. So.
Okay.
He was going to be here today too, but he told me that he would have some extenuating circumstances as to why he couldn't. So I reassured him that I would tell you that he has been working pretty diligently on getting it taken care of. Yesterday when we spoke about the overgrown lawn portion, I guess there's a bunch of tree debris that's underneath a bunch of the vegetative matter, so you can't just get in there and start cutting. So he's waiting on a part to get repaired for his tractor. Because I asked him if he knew how much time he would need, and he was unable to give me a timeline. But it's pretty extensive out there.
Yeah. I mean, they're both pretty substantial.
Yeah.
How big are the How big is the parcel?
This parcel in particular, it is 0.90.
Okay.
But essentially, it's a larger area that has different separate addresses on GIS. So
Okay.
so technically on the PA, the 2 cases that he had at the other address were combined on this same lot. So this lot is a little bit smaller that he's got to do. It's not exactly 0.90, but with his condition, and I've seen how mobile he is out there, and he's pretty limited on what he can do. But
Do you have any immediate health, safety, sanitary concerns?
I don't have any immediate ones for what I can tell. But yeah, I mean, I guess he inherited the property from his landlord, and he's just been working to
I just
bring it
think
up
it's
to
not
standard.
an easy job,
Oh, I
especially for someone
100% agree.
in his position. that-
Even portions of the property, I mean, all my photos are taken from the roadway, and you're looking down into the property. So I know that him navigating that left side
Right.
of it, where it's really overgrown, is gonna be pretty difficult.
All right, then I'm gonna grant 90 days in each case.
Okay.
What's the county's recommendation on a fine?
$50 a day.
$50 a day, if not, brought into compliance as ordered.
Great, thank you.
That was was that the last hearing?
That
Yes,
was.
sir.
Is there anything else that the county wants to take up? Okay, the time is 12:47, this hearing is adjourned.
Thank you.
Want to take some of these with you?